Attorney General Ken Paxton is underway. Hello, I'm Steve Eager.
Hello, everybody. I'm Heather Hayes. The proceeding is political, not criminal, but it does pose the greatest threat so far to Paxton's career. Through his attorney, Paxton entered not guilty pleas to 16 articles of impeachment. The case centers on his relationship with real estate developer Nate Paul and whether Paxton abused the powers of his office to help Paul and to cover up his own wrongdoing. Fox 4's Sean Rabb in now with more on the trial coverage. Sean.
And the House managers in opening statement said the now suspended Attorney General used the office for his own benefit and should be removed. Paxton's attorneys called the charges untrue and incorrect. And now we also know Paxton cannot be forced to testify.
Our first order of business is to address 24 pre-trial motions.
And senators serving as jurors voted no to 16 defense motions to dismiss everything from articles of impeachment to certain evidence. In this political trial where the Attorney General is accused of misusing his power, abuse of office, fraud, and accepting bribes from friend and political donor Nate Paul.
This court notes that many factors and circumstances in this proceeding lean more on criminal in nature.
One early victory for Paxton, Lieutenant Governor Dan Patrick deciding that many of the rules in this impeachment proceeding lean towards the rules in criminal court, including whether the accused can be forced to testify.
And the House of Managers have repeatedly compared the actions of the House of Representatives to a grand jury. As they prefer the articles of impeachment, grand juries are utilized only in criminal cases. Therefore, the motion is granted. The Attorney General cannot be compelled to testify.
We never heard from Paxton during day one of proceedings. Standing between his attorneys as Tony Busby entered not guilty pleas to each article of impeachment.
Attorney General Paxton, how do you plead?
Stand by that report and therefore plead not guilty.
Your Honor, objection.
Busby's not guilty pleas with emphasis brought an objection from House Manager's attorney Rusty Hardin.
I ask that he just be instructed to plead not guilty or guilty, whichever he chooses, but not to be making speeches to his lawyer.
Sustained.
After lunch, Ken Paxton did not return to the chamber-turned-courtroom where House Manager Andrew Murr painted Paxton as using his office and power for personal gain. Murr arguing there's much voters don't know about Paxton's alleged misconduct when they re-elected him.
Mr. Paxton has been entrusted with great power. Unfortunately, rather than rise to the occasion, he has revealed his true character. And as the overwhelming evidence will show, he is not fit to be the Attorney General for the state of Texas.
Busby, Paxton's lead attorney, told senators what was happening here was a whole lot of nothing, that Paxton did nothing wrong, and then turned his remarks pointedly to the senator jurors with a swipe at media reporting, much of it based on troves of documents published by the impeachment managers.
Have you already decided, based on what is politically expedient or what's best for you personally? Or is it even possible to get a fair hearing? Especially after this case has been tried in the press, Ken Paxton has been convicted in the press based on ignorance, innuendo, and outright lies.
Late this afternoon, the first witness took the stand, James Mateer, longtime second in command at the Attorney General's office, one of 8 who went to the FBI, but not one of the 4 whistleblowers. Through him, House managers and Attorney Rusty Hardin are starting to try and build this overly interesting relationship that Ken Paxton had in the affairs of Nate Paul. Testimony has concluded for today. Will begin tomorrow morning at 9 a.m.
Okay, Sean Rabb, I guess it's not like a criminal case. It is, but it's not. He doesn't have to testify, and those guys aren't jurors. They're men and women in the Senate, so.
It's like a criminal case, has all the leanings of a criminal case, but won't have the criminal outcome if he is found guilty.
There's outside pressures, too, politically on all of them. All right, Sean Rabb, thanks.
All right.
Among the key moments during testimony in Ken Paxton's impeachment trial was the meeting a prosecution witness described where Paxton admitted having an affair.
So the witness, a former top aide in the Attorney General's office, said that explains some of Paxton's unusual behavior. But that witness testified the real cover-up happened when Paxton resumed the affair. And more details were revealed about what he and others told the FBI about Paxton's questionable dealings with an Austin businessman. Fox 4's Blake Hansen in studio tonight to take us through today's testimony. Blake.
As Steve and Heather, this was effectively the first full day of testimony, much of it centering around Paxton's former top deputies and what they witnessed on the job.
I was quite frankly sick of dealing with Nate Paul.
It was another one of Ken Paxton's former top deputies and whistleblowers taking the stand late Wednesday. Ryan Bangert talked of donating to Paxton's campaign before joining the office and being a fan of Paxton's work.
I believed in what he was doing. I believed his policies were the best for Texas. That's why I joined his office in 2019.
But Bangert says in 2020, Paxton began asking him to intervene in matters involving Paxton's friend and campaign donor, businessman Nate Paul. At the heart of prosecutors' case are accusations Paxton allowed Paul to use the AG's office to his benefit. Bangert says Paxton requested they intervene in an open records dispute, a dispute between Paul's businesses and a charity, and more.
Is that the third time you've now been asked within 6 months to review a matter that involved Nate Paul?
Yes, yes.
So at this time, how would you characterize your feelings about whether or not the AG's office ought to be getting involved in anything that involved Nate Paul?
My feelings were that I was becoming increasingly concerned.
Bangert described unusual behavior when Paxton asked them to rewrite an opinion about foreclosures to do the opposite of staff's suggestion.
It was bizarre.
And why was it bizarre?
He was acting like a man with a gun to his head.
In what way?
Anxious, desperate, urging me to get this out as quickly as humanly possible.
Bangert described taking off one of his staffers' signatures and adding his own to the opinion for fear it would tarnish the young man's career.
I changed it to go out under my signature.
And why?
At the end of the process, I had become very alarmed by the Attorney General's behavior. I had promoted Ryan Vassar into that position myself, and I felt a degree of responsibility to him.
Before Bangert, we heard from former First Assistant Attorney General Jeff Mateer. He recalled in September 2020 how Paxton and his wife, State Senator Angela Paxton, called an emotional meeting with senior staff.
Mr. Paxton revealed that he had been engaged in an extramarital affair and asked for our forgiveness.
But then Mateer says he learned the affair had resumed. He and others alleging Paul manipulated Paxton for favors to help cover it up. On cross-examination, Paxton attorney Tony Busby and Mateer were heated at times. Busby sought to downplay Paul's influence over Paxton.
In 2018, what percentage Nate Paul's campaign contribution was with regard to the total amount raised by Ken Paxton?
Well, if your math is correct on this demonstrative, it's there, but I wouldn't have known that then, no.
0.37%.
Busby also directed questions about who knew what, when, about reporting Paxton to the FBI.
You were involved in staging a coup, weren't you?
Absolutely not.
You were staging a coup, weren't you?
Absolutely not.
The prosecution is not yet done with its questioning of Bangert, and he has yet to face cross-examination from the defense as well. Stephen, Heather.
All right, Blake, likely see you tomorrow and maybe the rest of the week. Thank you very much. There was dramatic and at times contentious testimony today at Ken Paxton's political trial in the Texas Senate. We also saw emotional moments from Paxton's former employees who went to the FBI complaining that their boss was allowing the Attorney General's office to be misused by a political friend. Fox 4's Sean Rabb, watching today's testimony, is here with the highlights again. Sean?
Steve, another whistleblower in the Attorney General's office who did not file a lawsuit said he felt the AG's office had been hijacked to help developer and Paxton donor Nate Paul. And Ryan Bangert testified the group of 8 who went to the FBI were not staging a coup, but wholly concerned.
Did you consider it a mutiny?
It was not a mutiny.
How would you characterize it?
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
That's how Ryan Bangert testified about going with others to the FBI, concerned about the relationship between Attorney General Ken Paxton and real estate developer, Republican donor Nate Paul. That assertion, though, challenged under, at times, combative cross-examination by Paxton attorney Anthony Oso Jr., with Lieutenant Governor Dan Patrick instructing the witness to answer.
Now, at no point after you reported to law enforcement Were you terminated from your position? It's a yes or no question, Mr. Bangert. Were you fired or were you not fired?
I was constructively discharged.
Now, I asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively discharged.
Bangert testified Paxton took him to a lunch meeting with Nate Paul, who complained about being treated unfairly and wanting the AG's office to intervene in his financial dispute with a nonprofit foundation that invested millions in some of his Austin projects.
What was your impression about that, what that whole meeting was about?
The strong impression that I had developed was I had been summoned to that lunch by Nate Paul to hear out his grievances and to convince me to get on board with the Mitty Foundation intervention program.
All of this happening while the AG's office was wrestling with much bigger issues, from a Google lawsuit and COVID.
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
One of those issues, COVID-related. A midnight order in August 2020 restricting to 10 the number of people attending outdoor foreclosure sales pushed for by Paxton. Bangert said he was against it, later learning Nate Paul benefited because he had multiple properties in foreclosure.
The Attorney General was determined to harness the power of our office and to fulfill the interests of a single individual against the interest of the state.
Under cross-exam, this hard line of questioning.
You're here to testify in the court of impeachment. Do you not remember the day that you went behind Ken Paxton back to the FBI? Do you not remember that?
Sir, we did not go behind the Attorney General's back.
Did you tell him you were going to the FBI? Yes or no?
Sir, we did not go behind the...
Mr. Bangert, I'm asking you yes or no questions. Did you tell Ken Paxton that you were going to go to the FBI?
On September 30th, we did not.
It's a yes or no question, Mr. Bangert.
It's not a yes or no.
It is a yes or no.
The mood in the chamber turned courtroom changed as witness Ryan Vassar, former Deputy Attorney General for Legal Counsel, tried to hold his emotions as he talked about being called rogue by his boss, Ken Paxton.
And it's contrary, the statement of being rogue is contrary to the years that I dedicated my life to the state.
U.S. Senator John Cornyn, on a call with Texas media today, called the impeachment trial very deeply disturbing and painful to watch. Continues tomorrow.
All right, Sean, thank you very much. We'll see you soon. As we continue to cover the impeachment trial, you can watch the live stream on fox4news.com, the Fox 4 YouTube page, and when we're not in a newscast, on Fox Local. That's our streaming app on Apple TV, Roku, Android, and Amazon Fire. It's free to download, and there is no login required. Whistleblower text messages and former Texas Rangers testimony dominated day 4 of suspended Attorney General Ken Paxton's impeachment trial. Paxton was again not present in the courtroom where his attorneys attempted to tear down previous testimony. Fox 4 Sean Rabb in studio with more. Sean.
And Steve, those whistleblower text messages in a group chat days after going to the FBI about Paxton. That former Texas Ranger who was over the AG's law enforcement division compared Nate Paul, the developer and Paxton donor at the heart of this political trial, with Billy Saul Estes. He was convicted of perhaps the most sprawling fraud scheme in history.
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
Former Texas Ranger David Maxwell, who was the Attorney General's law enforcement director, testified what he told Ken Paxton about Nate Paul after his first meeting with Paul, a meeting he was told to have by Jeff Mateer, who testified Tuesday. Maxwell had 2 meetings with Paul and his attorneys that were recorded, and a third meeting that included Paxton, not recorded at Paxton's insistence. Paul, Maxwell said, was angry, pressing for the AG's office to investigate DPS troopers, FBI agents, and a federal judge in connection with search warrants at his businesses and home.
And I told him that all you're doing is using the power and the prestige of this office for your own purpose, and I'm not going to allow that.
Maxwell says after that meeting, Paxton never spoke to him again. 2 months later, he was placed on leave. A month after that, he was fired.
You are insulting your colleagues on this group chat among friends. True?
I wouldn't describe it as insulting.
Text talk between the whistleblowers after they went to the FBI, also part of Day 4 testimony, joking about Ken Paxton and other staff in the AG's office not being smart. Ryan Vassar, who testified through tears Thursday at being called a rogue employee, posting a link in the chat to a coloring book, suggesting new staff needed something to entertain them.
It was a joke.
I believe earlier your testimony was that being called a rogue employee was very upsetting to you, right?
Yes, sir.
But this is how you talk about your coworkers, true?
Again, it was lighthearted. It was among friends. It was not made public to millions of people.
Lawyer Little tearing at previous testimony that Nate Paul's issues overwhelmed the Attorney General's office.
How many lawyers are there roughly at the Office of the Attorney General?
Roughly 800 lawyers.
How many of them ever touched anything related to Nate Paul? How many of the 800 ever touched anything related to Nate Paul?
I could speculate there may have been 15 lawyers, maybe 15 to 20.
With 20,000 active cases at any given time.
And how many of those 20,000 cases involve Nate Paul?
I would have no direct knowledge of how many of those cases would.
The cross moving to the so-called August 2nd midnight order that restricted the number attending foreclosure sales. Nate Paul had 13 properties set to be sold August 4th, 2020. Little pressed on whether it was just one of many COVID guidances being released almost daily.
Orders similar to this that were giving informal legal guidance about COVID matters were coming out of your office almost every day. True?
I'm not sure if it was daily, but we were providing advice on a regular basis.
Now, each side has been given a total of 27 hours to present their case, and we are more or less halfway through that allotted time. Testimonies ended for now, resumes Monday at 9 a.m.
Day 5 of suspended Attorney General Ken Paxton's impeachment trial is marked by a whistleblower testifying that Paxton's friend and campaign donor acted like he was the real boss of the AG's office.
The witness said he warned that Paxton could put himself in legal jeopardy by helping Nate Paul, and that Paxton expressed a personal grudge against law enforcement. Fox 4's Sean Rabb joining us in studio with more of today's testimony. Sean.
Yes, former deputy over criminal justice spent about 4 hours testifying about phone calls and meetings with the Attorney General around Nate Paul, who is the subject at the center of this impeachment trial with Ken Paxton. In a meeting with Paxton and Paul, Mark Penley informed the office would not investigate his claims any further, and that, he testified, brought an angry response from Mr. Paul.
Mr. Paul acted like we didn't understand who the real boss was. It wasn't the Attorney General, it was him. That was his body language, that was the expression on his face, the way he bowed up. He got very unhappy with us.
Nate Paul wanted the Attorney General's office to look into his allegation that laws were broken during the search of his businesses and home by state and federal authorities. Paul wanted the AG's office to investigate troopers, FBI agents, an assistant U.S. attorney, and a federal judge. Mark Penley said he and former AG Law Enforcement Director David Maxwell, who testified Friday, decided to slow walk the investigation, hoping Paxton would drop it because he thought it was crazy.
Why did you think it was crazy?
The idea that the state of Texas Attorney General's office would go investigate the federal courthouse, investigate federal agents and also state agents that were task force officers on the raid, and those were agents from the DPS and the State Securities Board, that we would investigate a federal magistrate judge and federal prosecutors was insane.
Penley, a former deputy in the AG's office, testified in phone calls and meetings Paxton kept pushing for Paul's claims to be investigated.
I asked him why he was so interested in this investigation when he was not interested in all the other criminal investigations and cases we had pending in the office.
All right. And what was his response?
His response was, I don't know about the other cases, but I know about this one, and I'm concerned about corrupt law enforcement because of what's happened to me.
That in reference to Paxton's 2015 indictment on securities fraud charges, still pending to this day. Penley told the court he met the Attorney General at Paxton's request at a Dunkin' Donuts in McKinney, September 26, 2020. That's when he learned Paxton had contracted Brandon Kamak as outside counsel, another extraordinary move to push forward Nate Paul's claims.
How was the tone of this conversation?
He was frustrated, and that was the most, it wasn't a hostile conversation, but it was a difficult conversation.
How did the conversation end?
I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it.
On cross-exam, Paxton attorney J. Mitchell Little focused on Penley and Maxwell, quote, slow-walking the investigation.
And Ken Paxton was upset with you that in 6 weeks, you and David Maxwell had done nothing. True?
Which part of the question do you want me to answer first? You asked me if we'd had it for 6 weeks. That is true. And it's also true we had done no investigating in that 6 weeks.
Challenging what proof Penley had that Paxton had done anything wrong.
On September 26, did you have any physical evidence, documentary evidence, eyewitness evidence, or circumstantial evidence that Ken Paxton had committed or been bribed by Nate Paul?
I had circumstantial evidence.
Anything else?
I had his behavior.
Anything else?
The campaign donation.
Anything else?
His absolute refusal to listen to common sense and reasoned legal positions. He wouldn't listen to anybody on the executive staff.
There was another staffer this afternoon testifying about the Paxton affair and the impact of the morale on the Attorney General's office. Now, this morning, Lieutenant Governor Dan Patrick says testimony could end Thursday. Each side will then get 1 hour for closing statements. Senators will have to stay in Austin and deliberate through the weekend if necessary until they come to a decision.
Okay, Sean, thank you.
All right.
You can watch the trial. It's streaming live on fox4news.com, the Fox 4 YouTube and Facebook pages. And when we're not in a newscast like we are at this moment, it's available on Fox Local. That's our streaming channel on Apple TV, Roku, and Amazon Fire. It's free to download, and no login is required.
Well, today, the Texas Senate heard testimony from the man Ken Paxton turned to when his own staff would not do his bidding.
Brandon Kamek served as special prosecutor, reporting to the now suspended Attorney General and digging into the criminal investigation against Paxton's political donor friend, Nate Paul. This is day 6 of testimony at Paxton's impeachment trial. Sean Rabb in studio again today with more on the testimony today. Sean.
All about Brandon Kamek. He was 5 years out of law school, never a prosecutor, had only 15 to 20 jury trials under his belt when on his cell phone on his birthday, Attorney General Ken Paxton. From August 2020 moving forward. He testified some point in September of that year. Paxton wanted him to communicate with him through something called Signal app, an encrypted communication, and that he did everything at the direction of Paxton over 6 weeks that would change his life.
Who in the Attorney General's office in a position of responsibility did you consistently have your contact with?
The only person I reported to was Mr. Paxton at his direction.
Brandon Kamek is the young, inexperienced lawyer in a solo practice who never worked as a prosecutor, but became outside counsel to the state's top law enforcer. Kamek said in his first meeting with Attorney General Paxton, he was excited.
Did he express anything, any views about his own staff or why he was hiring somebody from outside?
Yes, sir. He said that he was interviewing multiple people, considering multiple people for the position, and that he couldn't get his own staff would not work on what he wanted them to work on.
What Paxton wanted was work on complaints brought to him by his real estate developer friend and campaign contributor, Nate Paul, who believed he had been treated unfairly by federal and state law enforcement. Kamek got the job, but did not have a contract. Meeting with Nate Paul and his attorney, Michael Wynn, September 4th, 2020. Kamek found Nate Paul convincing.
If what he's showing me on how the search warrant was altered is true, this is a big deal.
He began working on the complaint made by Nate Paul. Then he received a second referral to investigate civil litigation in bankruptcy court.
I spoke with Mr. Paxton about the referral because I wasn't sure if my scope of my contract covered that.
Sure.
And so, you know, he said that it did. And so I was like, well, I'm going to rise to the occasion. I'm going to figure this out.
Kamek testified he constantly asked for credentials, a badge, an email, something to prove he was working as a special prosecutor for the Attorney General's office, but never got that. and began preparing subpoenas in both cases, emailing some, delivering others to financial institutions in person. Nate Paul's attorney insisted, he says, on going with him. But as a sign of the conflict between Paxton and his own staff, when subpoenas were delivered, Kamek got cease and desist letters from none other than the Attorney General's office and a visit by U.S. Marshals. He testified the first time he had a contract signed by Ken Paxton was September 29th, given to him by Nate Paul's attorney, and that he attended a meeting after that at Paul's house with his attorney and Paxton, but he still had not been paid. Early October, Kamek met with Paxton and others at an Austin Starbucks. Kamek asked about getting paid and was told by the AG's new first assistant, Brent Webster, that the contract signed by Paxton was no good.
I think I ballparked and I said, what about my $14,000 invoice? And he's like, well, you're going to have to eat that invoice. I've had to eat $40,000 invoices.
Now, Mr. Kamek testifying that was Brent Webster telling him that, look, while the prosecutors are trying to prove certain elements of the articles of impeachment, the defense needs the jurors to see otherwise. I mean, a lot of bad things may have happened to and around Brandon Kamek's practice over those 6 weeks in 2020. But the question is, did Paxton do anything rising to the level of an impeachable offense? After all the testimony about contracts, secret communication, and everything else, does any of it equal impeachment?
All right, we're about to see very soon. Sean Rabb, thank you.
All right.
You can watch the trial streaming live on fox4news.com, the Fox 4 YouTube channel, and Facebook page. And when we're not in a newscast, you can watch Fox Local. That's our streaming channel. It's free to download on Apple TV, Roku, Amazon Fire, and Android TV. No login is required.
A bizarre day at the state capitol during day 7 of Ken Paxton's impeachment trial.
So it started when Paxton's mistress was called to testify, but right before her testimony, things changed. She left, and Lieutenant Governor Dan Patrick, who is acting as judge, said she was no longer available to testify. Then the lead impeachment prosecutor made a mistake, one that Paxton's attorneys jumped on in an effort to get the whole trial thrown out. Fox 4's Peyton Yeager breaks it down during the tail end of the testimony today. She's in studio. Peyton.
Steve, due to a technical issue this morning, we essentially had to wait all day on day 7 of the trial to see if Paxton's mistress, Laura Olson, would take the stand. We know she was present at the state capitol and has never spoken publicly before. However, just before 5 p.m., she was deemed unavailable to testify. Late Wednesday, the highly anticipated testimony from Laura Olson, the mistress of suspended Texas Attorney General Ken Paxton, was called off at the last minute. Olson, pictured here with Lieutenant Governor Dan Patrick back in 2018, was seen at the state capitol Wednesday. But Lieutenant Governor Patrick, who was overseeing the trial in the Senate, made a surprising announcement.
Members, for the record, the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify. As soon as we get the witness in, we can continue.
In the live stream, you could hear a few rumblings from the audience in confusion. The Lieutenant Governor repeated himself.
I said the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify.
Olson, pictured with State Senator Donna Campbell on a Bexar County GOP Facebook page in 2018, used to work for Senator Campbell. Evidence submitted by House managers alleged Paxton misused his office to help his friend, Austin businessman and donor Nate Paul, who was under investigation by the FBI and has been charged with 8 felony counts. The evidence suggests Paul hired Olson at his business, making it more convenient for Paxton to be close to her. But Patrick repeated a third time Olson would not testify after all.
The statement has been made by the court. It says what it means. Both sides have agreed to that statement. Both statements have agreed to that statement.
According to media reports, Olson allegedly planned to plead the Fifth during her testimony, so both sides agreed to move on. We spoke to constitutional lawyer David Cole moments after the Olson decision.
She'd been summoned to come The issue of whether or not she could be made to testify and assert the Fifth was still in play. The last bit of argument about that took place today, and the Senate made its decision during the course of the day, and that led to the statement about availability. I don't think they would have called her down there if they knew, that there just was going to be a no-go at the end of the day.
Cole says without Olson's testimony, it hurts the House managers.
Well, only two people know the truth there, Ms. Olson and Mr. Paxton. Neither one of them is going to be testifying now. So there's kind of a gap in that part of the story that the House managers previewed.
All right, good morning, everyone. I'm Blake Hansen in our Fox 4 studios. We are
in session. The Honorable Lieutenant Governor and President of the Senate, Dan Patrick, now presiding.
See, the proceedings are getting underway right now. The procedural aspects on what could be the final day of this historic impeachment trial of Attorney General Ken Paxton. A bit of news already before things have gotten started. Attorney General Ken Paxton is in the Senate chambers this morning. It is the first time we have seen him since day one of this trial getting underway. He was there for the very beginning of this and left a short time after. Some had wondered if that might impact the senators, the jurors' view of how seriously he took these accusations. We will certainly or possibly find out by the end of the day if that had any bearing at all on those jurors' minds. Again, we will begin with the closing arguments once the official proceedings get underway. You see some of the senators, the jurors who are entering the Senate chamber right now. We've seen Attorney General Ken Paxton sitting alongside his lead attorney, Tony Busby, laughing, joking, looking relaxed. You see Senator Angela Paxton there as she glances over at the defense team as she makes her way in. She will, of course, not be voting when it does come time to make that decision and choose the fates, decide the fate
Senator Alvarado,
of her husband and Attorney General
delivering
Ken
the prayer
Paxton.
this morning.
See the prayer getting underway shortly from Senator Alvarado out of the Houston area.
In the Father, Son, and Holy Spirit, amen. Heavenly Father, in this sacred chamber, we come together as servants of the great state of Texas, united by the privilege of serving our fellow Texans and serving you, Lord. As we near the end of these proceedings, let us take a moment to reflect on the weight of our task and express our gratitude for the trust placed in us. We recognize the solemn responsibility that accompanies our positions, and we pray for the guidance and wisdom needed to make decisions that honor the best interests of the state of Texas. As we stand here today, representing different communities and backgrounds, we are thankful for the strength that comes from our differences. It is through unity and collaboration that we find common ground, work together harmoniously, and uphold the values that define this great state. We are grateful for the opportunity to serve, for the chance to make a difference, and for the trust that has been bestowed upon us. May your grace shine upon this chamber, lighting our path as we navigate the challenge before us with humility and dedication. With your presence, Lord, as our guiding light, we are confident that we will meet this challenge with unity, integrity, and a shared commitment to the people of Texas. In your name, we offer this prayer. Amen.
Amen. You may be seated.
So to outline and kind of prepare you for what to expect in the closing arguments, one thing we want to keep in mind is this is not a typical jury situation. The senators, when they do reach a point where they deliberate, do not have to reach a unanimous verdict. They will be voting individually. 21 senators required to find guilty on any of those 16 articles of impeachment that are being considered through the course of this trial. What the senators no doubt are keeping in mind is what sort of argument, especially for these moderate Republicans, what sort of argument could they take back to their voting base if they do decide to vote for removing Attorney General Ken Paxton from office? And you'll no doubt see the House prosecution team as well as the defense trying to kind of frame those arguments and set the stage and hint at the possible political risk, because again, this is a political trial at the end of the day. We've heard Lieutenant Governor Dan Patrick say that time and time again, that even though there is an oath that these senators are taking at the start of this trial to serve as jurors, to act impartially,
those who are watching online,
politics are at play.
Before I begin, I have a few remarks to make. I first want to thank our clerk, Patsy Spa, and her entire team, and Austin, our bailiff, and all his team for their work during the trial. I've had questions, who are these people behind me? They've never been introduced. This is Darrell Davila, my chief of staff, former prosecutor, strong legal background. This is Chris Sterner, my legal counsel, strong legal background, working for governors before this, and Lola Fender, our deputy chief counsel. They've done tremendous work. And of course, Judge Lana Myers, who served as a prosecutor on a criminal court in Dallas and on the 5th Court of Appeals. I would not have been able to work through these last 2 weeks without them. As I said on day one, I've never been to law school, I've never taken a course, but we prepared for the last 3 months to do the very best job that we could to present a fair trial, which I think we have done to both parties during this time. We've read thousands of pages of documents of history of legal proceedings, and I even took a little bit of a judge boot camp along the way. So we've done the very best we can, and in a very short period of time, the trial will be in the hands of 30 members of the Senate who will vote. This impeachment trial, for only the third time of a statewide impeachment in the history of Texas, has been closely monitored, either through the media or through people watching online each day. I want to take a few minutes to go over a few of the key rules and to explain about what is to happen, because this is an unusual proceeding, not a normal trial. And I want to be sure the media reports it correctly and that the public understands everything we do will be in total transparency throughout this process. First of all, we've talked about the rules a lot in here. The rules were written and voted on by the members of the court. The final vote was 25-3. And these rules set out the framework for what has happened and what is about to happen. Let me highlight a few of the rules that we often get the most questions on. Pursuant to the rules written and adopted by the senators, Senator Angela Paxton cannot vote because of a spousal conflict. That's in Rule 31. However, the members kept the threshold to convict on any article at 2/3 of 31 members. That means it still requires 21 votes to convict, even though only 30 senators will cast a vote. It only takes a conviction on one article of the 16 articles to remove the Attorney General from office. Like any jury, the senators will deliberate in private, but under Rule 28, the senators will cast their vote in open court on the Senate floor without debate, one article at a time, after each member has finished their deliberations. All 16 articles will be voted on. I want to point out that under Rule 28, it provides that an article of impeachment is not divisible. What does that mean? That means the senators must consider each allegation in each article and determine whether the managers have proved each allegation in an article beyond a reasonable doubt before they can consider whether an article warrants removal from office. Then and only then may an article be sustained. For example, if an article has 3 allegations in it and only 2 are proven beyond a reasonable doubt in the mind of a senator, then a member shall not vote to sustain that article. Members, under the rules you adopted, I will read jury charges as written in Rule 27 after the conclusion of the final arguments. As I said in my remarks on opening day, your decision must be based only and only on the facts and evidence presented here in this chamber. You are the sole judges of the credibility of the witnesses. Evidence consists of the testimony of the witnesses and the materials admitted into evidence during this trial. Statements by attorneys in this trial are not evidence. Questions asked by attorneys are not evidence. I have no idea of how long the jury is going to deliberate. It could be hours, it could be days. Once they have notified me that all members are ready to vote, we will alert the media for a time certain when the members will come to the floor to cast their votes. And we will post that on the impeachment page of the state website. We will try to give the media and the public ample time to be ready for that time certain, at least 30 minutes notice. I know you are interested in the outcome of the trial, so check in on the website from time to time. No evidence whatsoever, members, outside this chamber shall be considered for any purpose. Nothing that I have said as presiding officer and judge, or that I have done, or how I have ruled, shall be considered as an opinion on facts or the case, and my words and actions should not influence your vote, one way or the other. I do not have the vote. You have the vote. The fact that the House of Representatives has preferred articles of impeachment to the Senate gives no inference of guilt. Like any defendant, the Attorney General is not required to prove his innocence or produce any evidence at all. The Attorney General is presumed to be innocent until proven otherwise. Even if a member believes the House managers have proven every element of an article beyond a reasonable doubt, the member may only sustain the article if they also believe Attorney General Paxton should be removed from office based on that article. The Senate jurors will begin deliberations today after final arguments, and they will continue as long as it takes. For the public, in some respects, understand this is like 16 trials in one. This is not a normal trial. They have to decide on 16 separate articles. Unlike a normal jury, the senators will not arrive at a group decision. When each member has come to their individual decision, they will come to the floor and vote one by one on each article. They will not have their phones with them during deliberations. They will not talk to staff during deliberations, legal counsel, or anyone else, members, only to each other during deliberations. They will be allowed, if necessary, depending on how long the deliberations go, to sleep outside the Capitol. But under strict rules, members, you shall have no communications with anyone. You may not look at television, you may not look at your phone, unless it's a call from a family member, and they should not discuss anything. It should only be for a family personal issue. You can tell your kids good night, or your wife or your husband, but you shall not read any news, look at any news, go online, open up your computers. Before retiring to deliberate today, after closing arguments, each juror will be given a copy of the articles of impeachment. They will also be provided with all the exhibits that have been admitted into evidence. Both sides will have 1 hour for final arguments. The House Board of Managers, having the burden of proof, has the right to open and close final argument. They may divide their hour into any time segments as they wish for open and close. That means the House Board of Managers will argue first and last, but only for that total of 1 hour. The Attorney General's legal counsel will also have 1 hour for final arguments. Once again, after closing arguments by both sides, I will read the charge as you have written in your rules to the jury, and you will begin deliberation. I will now read the articles of impeachment. Article number 1, disregard of official duty, protection of charitable organization. While holding office as Attorney General, Warren Kenneth Paxton violated the duties of his office by failing to act as a public protector of charitable organizations as required by Chapter 123 Property Code. Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Mitty Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation in an effort to benefit Paul. Article number 2, disregard of official duty, abuse of the opinion process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to issue written legal opinions under Subchapter C, Chapter 402 Government Code. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of a Senate committee to serve as a straw requester. Furthermore, Paxton directed employees of his office to reverse their legal conclusion for the benefit of Paul. Article number 3, disregard of official duty, abuse of the open records process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. Article number 4. And both parties had asked me to read these articles before their closing arguments. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information of benefit to Nate Paul. Article number 5, disregard of official duty, engagement of CAMIC. While holding office as Attorney General, Warren Kenneth Paxton misused his official power by violating the laws governing the appointment of prosecuting attorneys pro tem. Specifically, Paxton engaged Brandon Kamek, a licensed attorney, to conduct an investigation into a baseless complaint, during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. While holding office as Attorney General, Article 6, disregard of official duty, termination of whistleblowers, Warren Kenneth Paxton violated the duty of his office by terminating and taking adverse personal action against employees of his office in violation of this state's whistleblower law, Chapter 554 Government Code. Specifically, Paxton terminated employees of his office who made good faith reports of his unlawful actions to law enforcement authorities. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice in their future employment. Article 7, misapplication of public resources, whistleblower investigation and report. While holding office as Attorney General, Warren Kenneth Paxton misused public resources entrusted to him. Specifically, Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints made by employees who Paxton had terminated, and to create and publish a lengthy written report containing false or misleading information or statements in Paxton's defense. Article number 8, disregard of official duty, settlement agreement. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by concealing his wrongful acts in connection with whistleblower complaints made by employees whom Paxton had terminated. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Article number 9, constitutional bribery, Paul's employment of Mistress. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul's employment of a woman with whom Paxton was having an extramarital affair. Paul received favorable legal assistance from or specialized access to the office of the Attorney General. Constitutional bribery, Paul's providing renovations to Paxton's home. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Paul received favorable legal assistance from or specialized access to the Office of the Attorney General. Article 15, false statements in official records, whistleblower response. While holding office as Attorney General, Warren Kenneth Paxton made false or misleading statements in official records to mislead both the public and public officials. Specifically, Paxton made or caused to be made multiple false or misleading statements in the lengthy written report issued by his office in the response of whistleblower allegations. Article 16, conspiracy and attempted conspiracy. While holding office as Attorney General, Warren Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more articles. Article 17, misappropriation of public resources. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by causing employees of his office to perform services to his benefit and the benefit of others. Article 18, dereliction of duty. While holding office as Attorney General, Warren Kenneth Paxton violated the Texas Constitution, his oaths of office, statutes, and public policy against public officials acting contrary to the public interest by engaging in acts described by one or more articles. Article 19, unfitness for office. While holding office as Attorney General, Warren Kenneth Paxton engaged in misconduct, private or public, of such character as to indicate his unfitness for office as shown by the acts described in one or more articles. Abuse of public trust, Article 20, while holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of the Attorney General into scandal and disrepute to the prejudice of public confidence in the government of the state, as shown by the acts of described in one or more articles. Just one moment.
So Lieutenant Governor Dan Patrick has been essentially prepping the public, the gallery, and the senators as well who act as jurors on kind of how the rest of the day will play out, and specifically trying to prepare people for some of the differences between a typical trial and a trial of this nature, where the senators will not be deliberating as a group. They will be coming to their own decision. We don't really expect deliberations to take all that long, but he did mention that if for some reason these deliberations carry on into another day, that those senators would be allowed to sleep outside the Capitol. However, they would not be able to watch the news. Their communications will be limited to, basically talking with their families on family matters and not issues of the actual impeachment articles that are under consideration. He also said that once those senators begin their deliberations, and they will be deliberating privately, being able to discuss with one another what they are considering, that there'll be at least a 30 minutes heads up once those jurors decide that they have had enough time to deliberate. Those senators have had enough time to deliberate. So we'll get a bit of a heads up so that everyone who wants to see the conclusion of the trial, wants to see how those senators each decide to vote, have an opportunity to tune in for that as well. 1 hour for each side in the closing arguments. We also know this will begin with the House, but they can split up their time. They could take 30 minutes to start, send it over to the defense for their closing arguments, and then the House could wrap up using their remaining half hour. They've got the ability to split that time as they wish. Obviously, this is all a result of the procedures that were voted on at the beginning and leading up to this trial, deciding, for example, that Senator Angela Paxton will not have a vote. However, even though that means there will be just 30 members voting, 21 members, at least 2/3 of the body, the total body number of 31, will be required to remove on an article of impeachment. The Lieutenant Governor also mentioning that the articles are not divisible, and so if you find a senator were to believe that parts of one of those articles did warrant removal, but parts did not, then the senator would not be able to sustain that article of impeachment. You see the Attorney General there sitting alone as his attorneys stand at the bench. Looked like he was taking notes as the articles of impeachment were read aloud again against him. As the camera pulls out, you'll see Senator Angela Paxton sitting on the opposite side of the Senate chamber, essentially able to witness this, able to be a part of it, but not actually have a say in what the fate of her husband and Attorney General Ken Paxton is. You heard the Lieutenant Governor as well thanking some of the participants at the start of the day. He has had help from a judge as well as other legal assistants guiding him through this. You heard the Lieutenant Governor mention that he does not have a background in any sort of legal field, and so he took a judge boot camp and has obviously been getting advice over his shoulders from some of those experts.
And then the defense will speak for their 60 minutes and the House will come back for the remaining time. I will give each, as they get to near the end of their hour time, I will give each side a 10-minute warning, a 5-minute warning, and a 1-minute warning. And I've told them that I'm not going to cut them off in mid-sentence, but they'll have to wrap up when I say their time is up. Mr. Murr?
Mr. President, members of the Senate sitting as Court of Impeachment, over the last 2 weeks, the Senate has faithfully carried out its constitutional duty to listen to the evidence. The framers of our Constitution placed a heavy and solemn responsibility on this chamber. The House did not come here lightly. We discovered unprecedented abuse in the Texas Attorney General's office by Mr. Paxton. As elected officials, we take an oath to protect the citizens of this state and the sacred public trust. The Constitution charges us with policing our own. If we don't keep public officials from abusing the capacity of their offices, then frankly, no one can. Mr. Paxton's attorneys like to remind everyone that he was elected by 4.2 million voters, but they have blindly ignored the fact that he has ultimately ended up serving one person, himself. Mr. Bangert explained Mr. Paxton's abuse of office in perhaps the most succinct way, and I'll direct you to your screen.
I was deeply concerned that the name and authority and power of our office had been, in my view, hijacked to serve the interests of an individual against the interest of the broader public.
With the help of Jeff Mateer, Ken Paxton was able to build an exceptional executive management team. Mr. Paxton's top advisors were thrilled to go work for him. They came to the office because they believed in him and what he stood for. They were unabashedly conservative, hardworking experts in their fields with rock-ribbed principles. He had hired the best and brightest to help run his office. Mr. Mateer explained at the beginning of trial that these advisors were committed to the rule of law and to conservative governance. In this trial, you have heard from 8 of Mr. Paxton's top and at one time most trusted advisors. There have been several discussions about what the evidence is, but of course their testimony is evidence. Mr. Paxton's advisors were excited about what the office was doing for Texas. They circled around Mr. Paxton and worked diligently to advance the promises that he had made to voters. The travesty is that Mr. Paxton's desire to deliver results for Nate Paul eventually tore the office apart. It metastasized and overwhelmed the office. When it came to Nate Paul, Ken Paxton abandoned and betrayed his trust in knowledgeable staff, his conservative principles, and his commitment to family values, the law, and his oath of office. He repeatedly demanded that his top deputies act as Nate Paul's personal lawyers and not the state's lawyers. He gave the keys to the office. His lawyers have come in here and tried to normalize his behavior. They're not denying that Ken Paxton did any of the acts alleged. Instead, they want you to believe there was nothing wrong with Mr. Paxton ignoring his senior staff's repeated warnings about Nate Paul. Hall of Fame Texas Ranger David Maxwell did not mince words. Your screen, please.
My evaluation of the allegations made by Nate Paul is that they were absolutely ludicrous, without merit, no probable cause, not even reasonable belief that a crime had been committed. The nature of the allegations that he was making were against the FBI, an investigator with the Texas State Security Board, 2 U.S. attorneys, the senior federal magistrate, Mark Lane, and others who were involved in the chain of the signing and execution of the search warrants on his business, his place of storage, and also his home.
Now, it is clear that Mr. Paxton's judgment was completely clouded by his distrust of law enforcement. But his failed judgment does not excuse his intentional abuse of office. Mr. Paxton wants you to find that even though Nate Paul's story was ludicrous, that it was completely fine for him to hire a 5-year practicing attorney as an outside attorney to do Mr. Paul's bidding. He wants you to find that it was completely okay for Mr. Paxton and Nate Paul's lawyer to direct Mr. Kamek to issue grand jury subpoenas against judges, court clerks, police officers, and the spouse of a lawyer involved in a civil lawsuit with Nate Paul. They even want you to believe that going and getting a grand jury subpoena isn't really a big deal. This suggestion is absurd. The ability to issue a grand jury subpoena is a substantial power wielded by our government, and allowing a private citizen to take that power to attack enemies is truly shocking. Now, Mr. Paxton has admitted that he does not know much about criminal law. When he asked for money from this chamber to settle the lawsuit filed by staff members he wrongfully terminated, he wouldn't even answer a senator's question about the hiring of Mr. Kamek, and instead deflected to a staff member that he said was better qualified to answer. But when it came to Nate Paul and his requests, all of a sudden Mr. Paxton knew best. He refused to reply on the expertise of his staff. He balked at their warnings. And then he hid his actions when he went around them in his attempts to move forward in helping Nate Paul. And he is continuing to claim he knows best. He is sitting here today saying that he was completely entitled to do what he did and that these witnesses were some part of some deep state conspiracy. But once again, Mr. Paxton's claims are divorced from reality. The fact that every action complained of would have benefited Nate Paul is not mere happenstance. As Mr. Paxton's counsel has said, there are no coincidences in Austin. Now let's be clear about what happened here. Mr. Paxton enjoyed the power of his office. He enjoyed his relationship with Nate Paul. It facilitated the life Mr. Paxton wanted. And Mr. Paxton willingly and blindly wielded the power he loved so as to maintain the relationship he needed. This is wrong. The power of the office of Attorney General cannot and should not be handed over to a private citizen to use to attack their perceived enemies. Mr. Paxton claims that he wants the truth, but he hasn't even bothered to be here for the whole trial. He came on the first day, he left at lunch, and now he's here for closing. Clearly, he thinks that he might just get away with this. Had he been here, he could have seen the hundreds of exhibits and the thousands of pages that have been presented to you with 13 witnesses over 7 days that the House have meticulously laid before you. Mr. Paxton put the risk of the citizens of Texas, of the businesses of Texas, and the lives of law enforcement at stake. As the state's top cop, this conduct is and was inexcusable. His actions are precisely the type of grave official wrongs that our Supreme Court has explained merit impeachment. He may claim to be one of us, but unlike the public servants here today, he has no regard for the principles of honor and integrity. He has betrayed us and the people of Texas, and if he's given the opportunity, he will continue to abuse the power given to him. Mr. President, I yield the rest of my time for my closing.
Mr. Busby? I'm going to get set up here, Your Honor. Mr. Busby? We'll start the clock when he begins speaking. I'm going to get set up here, Your Honor. We'll start the clock when he begins speaking. House, you have 50 minutes and 35 seconds remaining.
May it please the court. Here we are in the Senate chamber in the most historic trial that's been had in this state in the last 100 years on this evidence. There is shame here, and the shame sits right there that they would bring this case in this chamber with no evidence. I am proud to represent Attorney General Ken Paxton. If this can happen to him, it can happen to anyone. Now, you heard when we started this case, you heard in the media that the evidence is 10 times worse than the public knows. But what a farce that was. What a farce that was. What we have seen instead is a bunch of supposition, mights, maybes, could have been. That's what we've seen in this trial. The very first witness they brought to you, the very first witness they brought to you, it's not working, crumbled under oath. Do you remember? Do you remember Jeff Mateer? Crumbled under oath. So what is this case about? It's about nothing. It's about nothing. Think about it. They failed to gather all the evidence. They failed to review their own evidence. They failed to talk to all the witnesses. Think about this. Brent Webster, the first assistant, did they bring him here? Did they even bother to ask him a question? They didn't even ask him a question. He is the man who reviewed and documented every single thing that occurred. They didn't even call him. You know why they didn't call him? Because he puts to bed all of their foolishness and silliness. They didn't take any sworn testimony. They let witnesses assume and speculate. They failed to even understand the law. And they couldn't even write the articles correctly. Look at the articles that the judge just read to you. They use words pro tem. Their own witnesses admit there was no attorney pro tem. They use words like the Attorney General failed to protect charities. That is not the Attorney General's job. And let me make sure we're clear about something here. When the House Board of Managers brought this case, they made an assumption. They assumed that this man would quit. They assumed that this man would run and hide. They assumed that Attorney General Ken Paxton would resign. Well, guess what? He did not resign. He is proud and is ready to go back to work. And after this is over, I expect he will go back to work. He has been a rock. He has been a rock, and that office, the Office of Attorney General, has accomplished more than any Attorney General's office in the country. You heard it from the witness stand. Biden's policies come to die in Texas because Attorney General Ken Paxton. Now let's talk about the burden of proof. We've heard about the burden of proof here and there. Is this working? Can I have 1 minute? Can we get this working?
Yes, I've been informed that the PowerPoint connection to your screens stopped as soon as he began his...
There are no coincidences in Austin.
We will stop the clock here for a moment.
We're going to take just a moment. Can we get this going, please? I need it for the senators to see the screens.
All right, a momentary pause for technical issues in the middle of the defense's closing arguments. You heard Tony Busby crack a joke about the no coincidences in Austin phrase we've heard throughout the trial that the defense first used. The House has somewhat used to try and attack the defense, or I guess jab at the defense a little bit, both yesterday and then again today. You heard from Andrew Murr, the House impeachment chair, bring up that comment again. What is interesting so far is that you see Tony Busby opening his closing arguments, talking about the evidence, but also tying in some of the political argument here, talking about that phrase, Biden's policies come to die in Texas because of Attorney General Ken Paxton. Because at the end of the day, again, this is a political decision that many of these senators will be weighing. And so this closing argument has both addressed what the defense believes is a lack of evidence, but also weaving in some of the political arguments into that discussion as well. Seems that they are getting ready to resume.
Okay, Your Honor. I think we're ready.
Do you want the screen to catch up to where you are?
Yes, sir.
Okay.
They thought he would quit. They thought they could bring a bunch of people, 15 people, not put under oath, with a bunch of supposition and guesses and mights and maybes, and they thought he would quit. The Texas Tribune, the Dallas Morning News, the Houston Chronicle, they thought he would quit. He did not quit. He did not quit. And he will not quit. Let's talk about the burden of proof. That is super important here. And I want you, senators, please, to look at your screen and look at the burden of proof. Beyond a reasonable doubt. Beyond a reasonable doubt. That means that you have no doubts that are reasonable. No doubts. That is an incredibly high burden. Can you imagine if we were in any criminal court in the United States that this case would not have already been dismissed based on what we've heard from this witness stand? This case would not, we would not be in final argument. This case would be over. But this is not a criminal trial. This is a political trial. I would suggest to you this is a political witch hunt. I would suggest to you that this trial has displayed for the country to see a partisan fight within the Republican Party. Let's just call it for what it is. That's what we're seeing here. It's being played out on TVs across the country. There is a battle for power. Because there's no doubt that these folks did not prove a case. They didn't prove a preponderance. They didn't prove anything other than they don't like Ken Paxton. Remember this fella, Greg Cox. You remember that guy? Greg Cox. Maybe, potentially, possibly, might have, perhaps, conceivably, could be. He testified that the Attorney General's office was so corrupt, they're involved in organized crime, but you know what? I want to go work there. What a joke. What a joke. I had texts from my former Marine Corps buddies that said that guy is a joke. To come in here in the Senate of Texas and to get on the stand, and these people sponsored this guy. What a joke he was. And in my view, that's exactly what their entire case has been. A joke. Much ado about nothing. The burdens of proof. Look at the burdens of proof, senators. Beyond a reasonable doubt. Now, if you decided this case from the Houston Chronicle, the Texas Tribune, Texas Monthly, the Dallas Morning News, oh my goodness gracious, Ken Paxton's guilty. But there ain't no evidence to support it. The only evidence we have in this case is they don't like Ken Paxton. And there is no doubt there have been hundreds upon hundreds upon hundreds of articles about Ken Paxton and how bad Ken Paxton is. Everybody has heard it, and guess what? The voters heard it too, and guess what? Ken Paxton won hands down, resounding victory. He beat the latest in line for the Bushes. Let it be known, let it be clear now. The Bush era in Texas ends today. We thought it had ended in the primary when Ken Paxton beat George P. Bush 68-32. Well, we thought it was over. It wasn't. Well, now we have an impeachment. It ends today. They can go back to Maine. This is Texas. This case has been nothing more than assumptions. And you know what my dad used to tell me? Assumptions make an ass out of you and me. And that's been this entire case. It's all built on assumptions and jumping to conclusions. Think about it. House repairs were paid for by Nate Paul. You know how sad this is? I had to come here on behalf of the Attorney General of the state of Texas and disprove their case because he had already been convicted in the press. And now we know. I had to prove it to young Drew Wicker. That young man believed, I heard a stray comment. And I jumped to a conclusion that the house repairs were paid for by Nate Paul. We all know now that was wrong. We all know now that was wrong, but that was in more than 100 articles across our country, smearing this man's name, smearing his wife's name, smearing a member of this body's name. And we all saw it. when we put this young man under oath and showed him the documents, guess what? Didn't happen. Wasn't true. And that is indicative of their entire case. We should not be in a position to where we have to come in here and prove our innocence, but we did. We did. The referral from the DA's office had nothing to do with Banks. All of his top lieutenants had no idea there was a second referral. You know why they didn't know? Because the referral went directly to Mr. Kamek. They didn't know about the direct referral from the DA's office. And you remember Margaret Moore? She came in here and tried to pretend like she didn't know anything about it because she wasn't supervising her staff. Her staff knew all about it. Her top lieutenant knew all about it. They assumed the Kamek contract was never executed, but now we all have seen that Ken Paxton, in fact, signed that contract. They assumed that Laura Olson's job was not legitimate, but now we have seen her employment contract. We've seen her application. We've seen that she's still working for world-class properties and still doing real work. They assumed that Wicker, young man Wicker, delivered a secret package in the middle of the night in a dark alley. Never happened. But if you were to watch the news and read the newspaper, oh my goodness, that happened. Even a Texas Ranger, think about this for a minute. You have a guy 6'6", wears a hat, cloaked with the authority of the state, comes in here and says to these folks, I heard from 5 or 6 people that Drew Wicker delivered a secret package in the dark of night in an alleyway on behalf of Nate Paul. Totally false. When he was asked, who told you that? Ranger. I can't even give you one name who told me that. Totally false. I asked the young man directly, did you ever deliver anything at night? Did you ever deliver anything that had anything to do with public records? No. Never. Didn't happen. Look at the position these people had put this man in and his wife. Prove your innocence, Attorney General. You've been convicted in the press. Prove your innocence now. If it can happen to him, it can happen to anyone. Foreclosures were stopped. There was a press statement that multiple foreclosures were stopped because of some informal guidance. Now we know that's false too. Presumed false. And these people got up here and used words like conspiracy, crimes, bribery, all kinds of really loaded words, and all were false. And this young man, Vassar, who cried on the stand in front of all of you because he had been called a rogue employee, at the very time he was called a rogue employee, he was joking and laughing and poking fun and calling his new boss, Brent Webster, a jerk. But when he came in here at the urging of these people, he cried. He cried because he had been called a rogue employee. What is a rogue employee? A rogue employee is somebody that doesn't do what the boss says. You don't do what the boss says? Let me tell you something. When I was a captain in the United States Marine Corps, and my staff sergeant didn't do what I told him to do, he can register his disagreement, but when the rubber meets the road and I tell him, this is what we're going to do, he does it or he resigns. What he doesn't do, what he should not do, what he should never do is go behind my back, cook up bar complaints, cook up a bunch of foolishness and go to the authorities. That's not how it's supposed to work. This guy, Mr. Vassar, Mr. Vassar came here, cried on the stand about being a rogue employee, but really the truth is at the same time he was called a rogue employee, he was laughing and joking about it. What foolishness is this? It's been 3 years since these so-called whistleblowers. Now think about what a whistleblower means. That means that you have to have evidence of a crime, and they admitted they had no evidence of a crime. And what have we heard from the FBI with regard to Attorney General Ken Paxton? Crickets. Nothing. Nothing. If you don't think that the Biden administration and its FBI and Department of Justice would not love to indict Ken Paxton, then you're not paying attention. They've done nothing. You know why they've done nothing? Because there's nothing to do. This man did his job, and he should still be doing his job. Staffers were not only wrong on their assumptions, they were wrong on the law. Can you believe that they didn't realize that the only person in that office that can actually have the authority to sign an outside counsel contract was Ken Paxton himself, and anybody else was designated? He's the only one that can do that. They didn't like that. This is a situation where the tail is wagging the dog. Imagine if one of your staff members at some point decided that, you know what, I don't think my boss has authority. I know more than the boss, so I'm going to be in charge now. That is not how it works. 4.2 million people decided who the Attorney General would be. They didn't elect Jeff Mateer, Ryan Vassar, Banger, none of those people. Those are political appointees serving at the pleasure of the Attorney General, just as every one of your staffs are as well. They even had the nerve to come here in front of you and say, well, I believed that when Ken Paxton was in Ohio doing his job and trying to put together a group of attorney generals in a case against Google, well, he's out of the state, now we're in charge. That is not how it works. That is not how it works. Let's cook up a bar complaint against Ken Paxton. Let's allocate $50,000 to hire an outside lawyer by the name of Johnny Sutton without any approval or telling the boss. They figured out real quickly, once they talked to Maxwell, that, you know what, we don't have anything. We need to beef this up. We don't have anything. And even though it's been 3 years, they still don't have anything. And 17 lawyers over there working since May, $500 an hour for each of them. Hundreds of thousands of dollars wasted, taxpayer money wasted, and they still don't have anything. Now, how did this happen? Well, they made some assumptions, and then they figured out they had no evidence, and it was too late to turn back. Recall that one of the witnesses, Mr. Mateer, Mr. Banger, said, well, once we went to the FBI, we were signing our death warrant. Rightly so. You go to the authorities with no evidence and accuse your boss of a crime, and there has been no crime, and there's been no evidence of any crime, and it's all a bunch of supposition and guesswork. Rightly so. And so they took a long walk on a short pier. The House managers did the same. The House managers did the same. They, in a 4-hour hearing, decided to impeach the Attorney General of the state of Texas, and then they spent months and months trying to collect evidence to support it, and they did not. They failed. And then the lobbyists got involved. The texts of support. TLR, yeah, we were against Ken Paxton. We spent $6 million against Ken Paxton. We couldn't beat him at the ballot box. Maybe we can beat him. Maybe we can beat him in an impeachment trial. George P. Bush decided, let me re-up my law license because maybe I can be the Attorney General now. I couldn't beat him in a fair fight. Maybe I can beat him here. And every one of these so-called whistleblowers, which are nothing but disgruntled ex-staffers, they all hired the same lawyer who just happens to be in the Ashcroft law firm, who just happens to be a protege of the Bush regime. The Bush era ends today in the state of Texas. Have you ever met a lawyer that works for 3 years for free, who's a former U.S. attorney, who's doing legitimate work? Legitimate work? I want to focus the allegations, as best as I can tell, of what Nate Paul provided to our Attorney General are in 3 buckets: campaign donation, house renovations, and Olson job. Let's focus on the first one. The allegation is there was some sort of quid pro quo. You have to have a quid pro quo for bribery. They've thrown this word bribery around. That has a lot of meaning. In this case, it has none. And let's focus on the person who supposedly bribed our Attorney General. This pain in the butt. This described pain in the butt, Nate Paul. Entitled, insistent, overbearing, manipulative, pushy, threatening, presumptuous, brash, assertive, forceful, militant, but he really believed that he had been abused by the federal authorities. And let me ask you a question. Do we really believe that the federal authorities do not sometimes abuse people? Do we believe that? Do we believe that the FBI is always on the up and up? Do we really believe that the Department of Justice is always out to do the right thing? Or can we all agree that sometimes they pick and they choose who they go after? And when the federal government comes after you, you better buckle down. This guy thought he had been targeted by the FBI. And the only thing that this man did was, let's find out the truth. Let's see if that's really true. That's all he did. Because he knows a little bit about people coming after you with no evidence. He can identify with that. Heck, we see it here. The very reason I'm standing here. He was come after by a group of misinformed, ill-advised people with no evidence. That's what Nate. Now, do I know whether that search warrant was altered? We will never know. We'll never know. Nate Paul thought it was. We'll never know. And to suggest that the keys of the Attorney General's office were turned over to Nate Paul, look at his correspondence. He was madder than a hornet's nest with the Attorney General's office. You're not doing your job. You have a conflict of interest. You guys are negligent. You're grossly negligent. He was mad. He was pissed because the Attorney General's office would not do what he wanted them to do. He wanted them to investigate. If you look at the correspondence from Nate Paul senators and you compare it to what you just heard from Mr. Murr here, you're going to see 2 different stories. Nate Paul was very unhappy with the Attorney General's office. That does not sound like somebody who had the keys to the office. He kept accusing the Attorney General's office of not being neutral. He accused the Attorney General's office of having bias. He accused the Attorney General's office of being in the bag for the Mitty Foundation. He accused the Attorney General's office of employing people that were against his interests. It does not sound like somebody who's running the Attorney General's office. There was one person running the Attorney General's office, and that man is sitting right there, and that is the man that should be running the Attorney General's office at the end of this day. But I urge you to look at the correspondence and compare it with what you've heard, not only from these people, but in the media. Nate Paul was very, very upset and very, very unhappy with the Attorney General's office. So much so that he threatened to sue, that he sent a letter and said, hold all of your correspondence because I am going to sue you guys for your negligence, for your bias. When you look at the documents and you compare it to the arguments, you see a much different picture. Now, the allegation, the first bucket is a campaign donation of $25,000 made in October of 2018. Everything that you have heard in this case was in 2020. So think about that for a minute. Their entire case, a campaign donation, a bribe, if you will, 2 years prior. Complete ridiculousness. Especially when you look at all the other people that Nate Paul gave money to, and especially when you look at the percentage just in the year 2018 of the donations received by Attorney General Ken Paxton. This man is a fundraiser. There is a reason that he raises money politically, because the people like what he does. The people like Ken Paxton. We know that a campaign donation as a basis for bribery is complete hogwash. Imagine if a campaign donation were considered to be a bribe 2 years before the acts complained of. Line up. We're going to be doing a lot of impeachments in the city of Austin. That bucket has no validity. That bucket is empty. And let's look at the buckets of what Ken Paxton supposedly did for Nate Paul: foreclosure guidance, CAMIC retention, public records, and MIDI intervention. But what you heard from the young man who spent more time with Ken Paxton than anybody, sometimes 24/7, 365 days a year, is there was never an agreement at all. He never agreed to do anything for Nate Paul and never got a darn thing from Nate Paul, with the exception of a lunch. A lunch. A lunch that was public, on a patio, for everybody to see. Most of the time, you would think, when people are doing something untoward, they want to hide it. These were public lunches for everybody to see. And if a lunch is a bribe, then boy howdy, we got a problem here, do we not? That holds no water. Let's look at Article 1. It fails just in its language. These people don't even know the role of the Attorney General's office. It is not a public protector of charities. It's a protector of the public's interest in charities. And we know that previously, Greg Abbott, as the Attorney General, had sued the MIDI Foundation, as a long and sordid history. But it's not just a history of problems. There is a recent history, starting in 2019, and I urge you to look at the evidence, at the memo that was submitted, at the memo that every one of Ken Paxton's subordinates reviewed before they all signed off on the intervention. This was not Ken Paxton causing anybody to do anything. This was subordinates who reviewed the evidence provided and decided we need to intervene. And it goes on and on. People punching their spouse, people being indicted for this and that, all kinds of problems. And the most important problem, the thing I think that the subordinates were really concerned about, is this charity that was only worth $15 million total is investing $3 million into a speculative land deal. The bottom line is, and what's so ironic and what's so egregious is that every single person who signed off on the intervention in the first article of impeachment came here and testified that that's somehow wrong, but they were involved in it. Utter hypocrisy. They not only signed off on the intervention, which only lasted 3 months, but they also signed off on an investigation of the Mitty Foundation. That article fails, period. Did they prove anything beyond a reasonable doubt with regard to that article? The only thing that we've seen beyond a reasonable doubt in that article is the Mitty Foundation has major problems and that the AG's office intervened, and now the Mitty Foundation stands to make millions upon millions upon millions of dollars on their speculative investment. And I wish I could get an investment like that. $3 million investment, they stand to make almost $20 million. That hurts really good, doesn't it? So we know the intervention is hogwash. Let's go to the written legal opinions under 402, Article 2. Well, it fails on its face because there was no written legal opinion, period. You heard our Lieutenant Governor charge you and explain to you that they have to prove what is in the article. They cannot prove this article because there was never a written legal opinion, period. That article is over. It's over. You can see it. This is informal guidance. This is not a legal opinion, period. But let's go a little further. They tried to drag Senator Hughes into this foolishness and put his name in this article. For what reason, I don't know, and act like having a straw requester was somehow wrong. And we all know, the people that work in the state's business in this city know that straw requesters are common. Every one of the House Board of Managers has been a, quote, straw requester at one point or another. We know that. And to put that in a public article, to somehow besmirch Senator Hughes is foolishness. But what was in Ken Paxton's mind when he was looking for this informal guidance? Well, if we want to know, we can look at his texts. His text sent directly to Mr. Bangert, who was working on the informal opinion. Look what he says. I think that it will impact people's lives in a good way if we do this right. Hundreds of people will be protected from harm and maybe devastation. These are real-time texts. This is not 3 years later with a bunch of cooked-up foolishness. This is the real-time thoughts of our Attorney General as to what he was thinking with regard to the informal guidance. And did you hear Drew Wicker? When he was asked about that, he said he knew a little bit about it. General Paxton says, we may prevent a grandmother from being thrown out of her home. And now they've turned this upside down. They've cooked it up and made it look somehow bad. And you know what's most ironic is the president of the time, at the time, Donald Trump, a month later issued the same guidance. And we know, of course, Nate Paul put his entities in bankruptcy and there was never any foreclosures anyway. This is what we have to do. We have to get up here and prove our innocence. How wrong is that? And did you hear the financial guy from the bank get up here and talk about they didn't lose a penny? That they not only didn't lose a penny, they made a fortune. That bucket's empty. Let's talk about the abuse of the open records process. Well, we've seen that is bull. We've seen that the misuse of official information, that was bull. Remember what you heard, that there was a secret delivery in the dark of night and a sealed package with top secret information. The problem with all that was all that information had already been released. It was already public. It was already public. And then when young Drew was asked, did you checked out for the general a packet that had a CD in it? Was that what you gave to Nate Paul? No, not at all. Total baloney. Never delivered any open records to Nate Paul. Never delivered anything secret. That bucket's empty. Article 5, the retention of Kamek. They say he was a prosecutor pro tem. Well, that crumbled on the stand, did it not? You have to vote on the language of the articles. That should be 30-0. There was never a prosecutor pro tem. Game over. But we still have to prove our innocence. So ridiculous. The office of the district attorney made a referral. Mindy Monford, I want you to please pay particular attention to her affidavit. She was one of the subordinates of the elected DA, and she made it very clear that it was her idea to do the referral. And you know what she said? I didn't think it was appropriate to send it to the Texas Rangers. I didn't think it was appropriate to send it to the FBI, so I referred it to the Attorney General's office. But guess what? It went to a Texas Ranger and a former U.S. attorney, and they didn't want to fool with it. That's what you call a punt. We don't want to do it, let's punt it. And then they tried to pretend like they weren't involved, even though Kamek didn't know how to do a grand jury subpoena, so he had to rely upon the DA's office to do it. They were intimately involved. They were actively involved. They were helping him get the subpoenas, and they never said, this is wrong. In fact, they thought, I'm glad you're doing it because I don't want to be investigating the people that I have to work with. And then when it was over, they tried to wash their hands of it all. With all due respect, typical politician. And then lied about it. Margaret Moore sent a letter that she made sure it was in the press that she didn't have anything to do with this at all. We all know that's not true. And she didn't even mention that there had been a second referral that was referred directly from the DA's office directly to this young man, Brandon Kamek. And that's the reason he sent the subpoenas that the DA's office helped him to issue. And they want to blame that on Ken Paxton, who had no idea about it. Kamek admitted, I never told him what it was my idea to issue subpoenas, and I never told him who they were going to be issued to. And Ken Paxton could not figure out why the devil will Maxwell and Penley not do their jobs. Ken Paxton had a chance to investigate the feds. He wanted to investigate the feds. He wanted to, because he had seen how they operate, picking and choosing who they convict or who they charge, weaponizing the FBI, abusing their authority. He had an opportunity. He could not understand why his subordinates would not do their jobs. Instead of fighting about it, he got outside counsel. And this young man, Mr. Kamek, who had a signed contract from the Attorney General of the state of Texas, was dealing with somebody the Texas Ranger had decided in his mind on a Google search. Think about this. Imagine, I hope Dave Maxwell never Googles me. He had decided before he even looked at it that Nate Paul was a criminal. My God. If that's how criminal work is done, that your top cop in the AG's office based on a Google search, decides somebody's a criminal, therefore I'm not going to investigate his allegation of wrongdoing of the feds. We got a problem. We got a problem. He decided on a Google search that he wasn't going to do a darn thing. He was never going to investigate his old outfit, the Texas Rangers. He was never going to do that. He's in the Hall of Fame, for God's sake. And Penley's not going to investigate the feds because that's where he spent most of his career. And Ken Paxton said, look, there's an allegation. Let's look into it. And the only thing he ever said was, just find the truth. So look at the points of view. You look through the prism. Ken Paxton's prism is sometimes the feds screw up. Kamek's point of view as a criminal defense lawyer is sometimes those who are making allegations are wrong and screw up. Maxwell and Penley, the feds never do anything wrong. The Texas Rangers never do anything wrong. And anybody that says they do, they're a criminal. God, that's fear. That's terrifying. That should terrify every one of you. And so he issued subpoenas, and he thought he was a special prosecutor. He was outside counsel, special prosecutor. Whatever he was, he had the authority of the AG's office only to investigate. To investigate. And that's what the young man was doing. And he made it very clear in his testimony. He was young, inexperienced, sincere, and energetic. And he was asked point blank, did you think this was baseless? He said, heck no. I thought it was persuasive. I thought it was convincing. And I was excited to be involved in it. Because if what was being alleged were true, that would be a, quote, big deal. The only thing that Ken Paxton ever told that young man is seek the truth. That's what I suggest to you. Seek the truth. Nate Paul got nothing. Nothing. It's a darn shame that we have to come and prove that, but we did. And these whistleblowers, so-called whistleblowers, in order to be a whistleblower, let this sink in order to be a whistleblower, you have to have a good faith belief that a crime has occurred. In order to have a good faith belief that a crime has occurred, you have to have evidence. And you heard Mr. Vassar admit when he went to the FBI, he had none. He had some guesses, he had some maybes, he had none. And if these folks would have done their job, you wouldn't have had to spend the last 2 weeks of your time doing their job. And you can tell from the text. You can tell from the text of these so-called whistleblowers, which what they really are is disgruntled ex-staffers. They were combative. They were insubordinate. They called their brand new boss a joke. How long would somebody on your staff last if they were texting their colleagues calling you a joke? You would fire them on the spot. He is a joke. We all know that when you bring in a new chief of staff, when you have a disagreement with your chief of staff and you bring in somebody else, that chief of staff is going to make sure that she or he brings in their own people. That's the way it works in politics, political appointees. And when you come in and you talk to your subordinates and they say, I won't work with you, what happens then? They leave. Nobody was ever mistreated. Nobody was ever talked down to. They were treated with respect. That's not what Brent Webster, the new first assistant, got in return. What he got in return is screams, shouts, hollers, and talking behind his back and calling him a joke. And then they joked about being fired. They were so torn up that they were joking amongst themselves, calling themselves the Cool Kids Club. The investigative report, I encourage you to read it. It's very lengthy. It's very lengthy. That's Article 7. It is documented and detailed. It explains everything that happened. It's a full investigation, and it's pretty darn good. and it lays out in great detail the events, and it's been unrebutted. They had a chance to bring Brent Webster, who was one of the authors of that report, who made sure that everything was documented. It's lengthy. It has exhibit after exhibit. It demonstrates that they did, in fact, take the Attorney General's name off of the letterhead. It's there in black and white, the emails back and forth when they did that. It's in that report. Now they say the report is false. And they throw around bribery. We know why they included this, don't we? Because it captures headlines. It captures headlines. And you know why they mention Laura Olson? Because it captures headlines. And they want to shame people. They want to shame people. They want to be morally superior to us all. There's no reason to have done that to this family. There's no reason to have done that to this family. This woman got a job. She got it on her own merit, and she continues to work even today. She's getting checks from her job here in Austin even today. She has an apartment. She pays for her own apartment. That bucket is empty. I'm not going to spend too much time on this, but let me say, I'm certainly not perfect, and I'm going to assume that all of you feel the same. Because we all have sinned and fallen short. The only person that cannot be forgiven is somebody who's so cynical that they don't ask for forgiveness. If this impeachment is based on a marital impropriety, then line up. Line up. We're going to be doing a lot of impeaching in this city. You should be ashamed of yourselves. Ashamed of yourselves. Bribery. They convinced Drew Wicker, based on a stray comment, that Nate Paul was paying for the renovations. It took me about 20 minutes to disprove it. They never asked for any of those documents. They never even asked. They never even talked to Kevin Wood, the contractor. They didn't even bother. They assumed it was true, and I had to come here on behalf of my client and disprove it. How wrong is that? And that was the most serious allegation. It wasn't just against the Attorney General of our state, but it was against a senator in our state. Did you see young Wicker's face on the stand when I disproved it? I had to disprove it even to the general's body man. And let me tell you, the press reports that again, I'm going to be lining up a lot of lawsuits because that is absolute defamation. Because now we all know it's absolutely untrue. And that was the entire basis of this case. Supposition, and it can happen to you. Not even going to go through it. No burner phones, no secret email address, no promise to help Nate, no agreement with Nate. Nothing. Nothing. You should be ashamed of what you've done here. We showed you the transaction from front to back. Now, there was some suggestion that, well, he decided to pay because he knew they went to the FBI. Total baloney. The documents show something completely different. I urge you to look at Mateer's text and look at the text to Chip Loper on the pavement. Look at the USAA docs that show that he was fighting with his insurance company trying to get paid for these very renovations and repairs that we have in evidence now. Every bucket of what General Paxton supposedly received, every bucket of what Nate Paul supposedly received, empty. Empty. So, what do they do now? Well, you settle a lawsuit. a lawsuit was brought against the Attorney General office, and you went to the legislature, which is what you're required to do, to get it funded. And the reason we decided to settle it, the reason they were begging to settle the case is because they didn't know what the Supreme Court was going to do. And Ken Paxton delegated that to one of his subordinates and said, hey, settle it if you think it's appropriate. And that was put before the legislature, and the legislature says, no, we're not going to pay it. And they were begging. The very people that came here to testify were the very people begging to get paid. It makes me mad.
You have 10 minutes remaining in your time.
So the Hail Mary, that's Roger Staubach. Remember him? The Hail Mary is, well, let's just throw in a bunch of malarkey at the end. Conspiracy, although there's no agreement and no furtherance of a conspiracy. Misappropriation, never happened. Dereliction of duty. Boy, when you're accused as a Marine officer of being derelict of duty, that's bad. Let's throw it. Unfit for office, abuse of the public. There's no evidence to support any of the articles. That means there's no evidence to support any of these articles. These are thrown in later because as you deliberate, there's going to be somebody say, okay, you're right. There's no proof of that. But we got this article. We'll use this to get him. We got to get him. We got to get him. Don't do that. That's not based on evidence. And that ain't the way it works. Just throw it at the wall and hope something sticks. That ain't the way it works in court, and that should not be the way it works in a historic impeachment proceeding. It holds no water. So why are we here? We're here because Dade Phelan got his feelings hurt. He was so drunk handling the House business, knowing full well that they had no evidence to support an impeachment and they hadn't done their homework. When Ken Paxton says, hey man, you embarrassed the devil out of yourself, you should resign, they sped up the process and impeached this man. You've seen the video. It's all over the internet. You know, my favorite author said, justice limps along, but gets there all the same. We should have never had to do any of this because this case is a case about nothing. It's a case about nothing. And people are watching. It's not just these people. There are thousands upon thousands of people watching at home who will sit in judgment, who have watched the evidence, who have been shown what has been alleged and what has actually been proven, and have seen that they don't match up. For me, as a son of a butcher and the son of a woman who worked in our high school cafeteria, who had the gift from God to go to Texas A&M and then go into our United States Marine Corps and then be able to become a lawyer, a member of the bar of our state, to be called to defend the sitting Attorney General of the state of Texas is a great honor. And it's a great honor to stand here in front of you. I know in the fiber of my being that all of this foolishness that they've accused this man of is false. But the only question I have in my mind is whether there is courage in this room, to vote the way you know the evidence requires. I think there is. I hope there is. I pray there is. I'm asking you to agree with the 4.2 million Texans who put this man in office as Attorney General, to put this man back to work and vote not guilty.
morning. I had planned on 30 minutes, but I have 5. So I guess there really are no coincidences in Austin. It may or may not surprise you that I'm going to go in a different way from my colleague, Mr. Busby, who's a fine lawyer. But I'm not going to yell at you. I'm not going to scream at you. I'm not going to point my finger and shake my fist. I just think, first off, no offense, but you're politicians. Y'all can probably get that faux rage quicker than most mammals. It's a skill set you got. I'm not going to attack my colleagues on the other side. I don't think they are good lawyers. I think they are great lawyers. They are living legends. But here's the point about that. Mr. DeGuerin, it is DeGuerin, Mr. Hardin, Miss Epley, Mr. Donnelly, some of the greatest lawyers in Texas literally could not put together a cogent case that could convince anyone that these things occurred beyond a reasonable doubt. These aren't second-chair misdemeanor prosecutors. They were the best of the best. They did the best they could. But the evidence simply wasn't there. And my friends on the committee, here's a pro tip. If you're doing this investigation that will literally cost millions and millions of dollars and take weeks and weeks out of our senators' lives, you know, one person you might have talked to, me. I've been representing Ken Paxton for 8 years. Do you think they could have called me and said, hey, Dan, we got a problem with Paxton. What about this dark night? What about this kitchen cabinets? What about this Brandon Kamek? I was literally, sorry, I said I wasn't going to scream, but I was literally having lunch with Mr. Donnelly when this was going on. Do you think? Before we wrote that check, he could have said, hey, Cogdell, buddy, let's talk. They didn't do that. I'm not the world's greatest lawyer, but I'm pretty easy to find. The fact that they wouldn't literally pick up the phone and call me, that's a clue that they were more invested in the conclusion that they wanted than they were invested into the investigation. How much time, Your Honor? 1.5 minutes. I would make a joke about my personal life, but I won't. Can I see the picture of Brandon Kamek? One of the things that's really harder than it looks when you are a criminal defense lawyer is to argue to a jury. I need the picture, not the statement. There we go. Thank you. And thank you, Eric, for everything. One of the things that's harder than it looks is trying to explain to a jury what reasonable doubt looks like. That, ladies and gentlemen, is what reasonable doubt looks like in this case.
1 minute left.
Mr. Kamek told you this wasn't a baseless investigation. This was a legitimate investigation. Look, I respect David Maxwell. I've known him for a long time. But with respect to that legacy, his milk carton has expired. It's over. When he gets up there and looks you in a straight face and says it's a crime to investigate whether or not something is a crime, come on. We were born at night, but not last night. That is dumber than a bucket of hair for a Texas Ranger to say it's a crime to investigate the legality of the search. By the way, that's how my friends Mr. DeGuerin and Mr. Hardin and I make a living. It's not a crime. It's not. But Kamek said, not a crime, legitimate, I believed in it. I thought that was something there. Paxton never asked me to lie, cheat, or steal. And I was doing the best that I could. That is game, set, match. I think that's the phrase. I don't play tennis. It's game over. The whole case was around this illegal relationship with Mr. Paul and Mr. Wynn, who they didn't call, and my friend Ken Paxton.
Mr. Cogdell, you're going to have to wrap up. I'm sorry.
Let me just say this. It was an honor to be here. Never thought I would. Thank you. But this is not about me. It's not about Ken Paxton. It's about whether or not you have a reasonable doubt. I suspect he did some things that you probably didn't like. I get that. I understand that. But that's not the issue. The issue is whether the proof is there that is so convincing that it convinces you beyond a reasonable doubt, the same standard of proof that's in a death penalty case. It's not. It's not. It's not. 2 words. 2 words. Not guilty. Thank you.
Mr. Myers, he went over about a minute, so I'll give you an additional minute. You have 51 minutes. Yes, would you remove your easels? And we're not going to take a long break. They have a chance to come right back up, but I will give you 5 minutes while they're taking down the stretch. But do not leave the chamber.
All right, we have a brief 5-minute break before the House resumes and wraps up their closing arguments. 51 minutes is the amount of time they will have to wrap things up. We'll wait to see which member of the House team is going to be delivering that remaining portion. It was Representative Andrew Murr, who was part of the original investigating committee, who got the ball rolling on this investigation into the Attorney General that resulted in the impeachment itself, who gave the first 10 minutes. Obviously, by allowing so much of the time, the House having 51 minutes now on the backside of this, it allows them more time to rebut some of what we heard from the defense. And it was a fiery and accusatory closing argument from Tony Buzbee. He's a charismatic attorney. We'd expect nothing less from him. He was this way throughout the trial. But you saw him both focusing on what he said was a lack of evidence, but also focusing on some of these political themes of conspiracy. You heard him say the Bush era is over multiple times throughout that. And for some context, George P. Bush ran in the primary against Attorney General Ken Paxton in this most recent election. Did not make it past the primary stage. Attorney General Ken Paxton, of course, went on to be reelected. And they have seized, the defense has seized on this news that George P. Bush reactivated his law license in the middle of this. Worth pointing out that an attorney general does not actually have to have a law license, according to the Texas Constitution. And they've also been critical of, you heard Tony Buzbee mention TLR, Texans for Lawsuit Reform. They've got a political action committee that has been supportive of George P. Bush in the past. And there were accusations that TLR denied that the organization was somehow involved in kind of lobbying senators in a public pressure campaign leading up to this trial. Again, TLR denied those claims. And so Tony Buzbee repeatedly was getting at the idea that there was some sort of conspiracy there. You even heard him accusing Dade Phelan in the course of these events, saying that the House impeachment team should feel shame. It was a very fiery closing argument, and it will be interesting to see now how the House board, the House impeachment managers decide to proceed. Do they focus primarily on rebutting the claims, to revisiting some of the evidence that they brought forth during the trial? You saw the first portion, that 10-minute portion, was fairly organized and scripted, with Andrew Murr referencing certain clips from the trial itself, playing those on the screens for the senators to see. A reminder that once these deliberations are done, the senators, the jurors in this matter, will be deliberating in private. They do not have to come to a group conclusion. And here's the numbers that we've got to keep in mind. 12 Democrats, if you assume those 12 Democrats all vote for removal on these various impeachment articles, it would require 9 Republicans to join. 21 is the total number required. That's the majority, supermajority threshold in this matter, 2/3, in order to remove from office. Attorney General Ken Paxton, as you see here, has returned to the Senate chambers. This is the first time we are seeing him since day one of the trial, and you heard Andrew Murr reference that in his closing arguments. He basically said that he could not be bothered to be here for the full trial and, quote, clearly thinks he might just get away with this. That was a question I think that we had going into the deliberations was, would Attorney General Ken Paxton's lack of involvement in this trial, when of course he does not have other job-related duties to attend to. He is suspended, has been since the impeachment articles were carried, and but has chosen not to participate or not be present during the course of these proceedings. The defense team, you see, is pausing momentarily. Their portion of this trial is complete. We'll see the House team with 51 minutes left to go over their arguments. As we talk about the numbers, one other thing I want to get across is that, as we keep in mind this is a political trial, these Republicans are going to have to go back to their districts and explain why they did or did not vote against Attorney General Ken Paxton. 6 of those senators are up for re-election in 2024. You see one of them there in the blue, that is Donna Campbell, senator from New Braunfels. There are 3 from the North Texas area, Phil King of Weatherford, Tan Parker out of Flower Mound, and Drew Springer out of Vernon. So 6 Republicans who are going to kind of still feel some of the carryover from all of this impeachment discussion as likely a central part of their campaigns. No doubt whoever is challenging those opponents are going to be making a central focus how these senators voted during these impeachment proceedings. Again, even though there is an oath of office these senators take, even though they are supposed to look at the evidence impartially, this is, as Lieutenant Governor Dan Patrick has said multiple times, a political trial. Tony Buzbee acknowledged that in his closing arguments, that there is a political aspect to all of this, and I think that is why you saw Tony Buzbee touching on some of those political notes, touching on how Ken Paxton has fought against the Biden administration, as well as this kind of conspiracy idea that the Republican Party is divided, and this is one part of the Republican Party attacking the Attorney General, which Tony Buzbee says this part of the Republican Party, the Bush-era part, is going to be done after this. That is according to Tony Buzbee, of course. We have been told that once the deliberations do start, that will happen privately, so we will not see much of the deliberations. We really don't know how long this will last. Lieutenant Governor Dan Patrick said before these closing arguments began that it could take hours, it could take days. I would not expect it to last that long, given some of these senators may have made up their mind pretty quickly and they do not have to come to a joint agreement, a group decision. You see Andrew Murr stepping to the podium. It appears he will. It appears that Andrew Murr will be the the one to wrap things up. Of course, he could also start things out and hand it over to one of the other attorneys or members of the House team. Sounds like they asked the senators not to leave the chamber. One of them, however, has, and so they were waiting for that one remaining senator to return before they resume with the closing arguments and really the final opportunity for this House team to convince the senators to remove Attorney General Ken Paxton from office. Again, we would expect that they spend much of this time addressing some of what the defense just told the senators. They reserved most of their time, an overwhelming majority of their time, to do that.
Mr. Burr, we did add a minute to your time because they went a minute over, so you have 51 minutes and a few seconds.
Thank you, Mr. President. When I gave the opening statement on behalf of the House managers, we told you that we wanted you to hear from the witnesses and see the documents. And so we're going to continue to do this. On your screen, we're going to start with Article 1. Now, we don't have enough time to go through every piece of paper that was introduced at trial and every word that was uttered under oath. But we suggest that you look at these key exhibits related to Article 1. To summarize, the Texas Attorney General wields astonishing power and is required to use that power to protect charities. In fact, the Fifth Circuit Court of Appeals has called it the public protector of charities. But instead of protecting the Mitty Foundation, Paxton forced his office into the Mitty lawsuit over the objections of the Charitable Trust Division solely to help Nate Paul and his companies. Mr. Paxton's obsession with helping Nate Paul manifested itself in the Mitty litigation when he demanded his deputies try to halt the lawsuit and force the charity to accept Mr. Paul's lowball settlement offer. Mr. Paxton claimed that the office needed to intervene to save the Mitty Foundation from excessive attorney's fees. But in reality, his actions harmed the charity by causing it to respond to frivolous motions and demands. Instead of protecting charities, Mr. Paxton harmed the Mitty Foundation only because he wanted to help Nate Paul. Now, in addition to exhibits, you heard testimony proving evidence in Article 1. Here's just one of the highlights from Mr. Bangert.
He directed us to intervene. It was clear to me the intervention would benefit world-class holdings in Nate Paul.
Article 2, same thing, trying to be compressed on time, but I want to give you a highlight of some of the exhibits that we want to direct you to. You can write these down and look at them later during deliberations. To summarize, Mr. Paxton abused his office, forcing his employees to draft the midnight opinion to help Nate Paul avoid impending foreclosure sales. He became involved in the drafting of an opinion for the first time ever. He covered up his misdeeds by creating a straw requester, a Senate chairman, to hide the fact that he had no valid requester as required by Chapter 402 of the Government Code. The letter was clearly a 402 opinion, and the Office of Attorney General knew that. Why else go to all the trouble to find an authorized requester? It doesn't make sense. Even though the Attorney General's office had been promoted as Texas is open for business during COVID, and Governor Abbott's emergency COVID order had expressly permitted real estate transactions to continue without limitation, Mr. Paxton forced his employees to stop foreclosure sales based on the phony claim that COVID made these outdoor sales on the courthouse steps dangerous. To accomplish this purpose, he forced his employees to reverse their legal conclusions, and they told you that, so that Nate Paul could benefit from a legal opinion published at 1 o'clock on a Sunday morning. The very next day, Nate Paul attempted to use the opinion letter to halt foreclosures in his properties. On your screen is Exhibit 657. Articles 3 and 4. Same thing. We have listed some of the top exhibits that we suggest you look at when you deliberate. To summarize, Mr. Paxton does not dispute that the law enforcement exception is designed to protect victims, law enforcement, informants, and practices. It is also undisputed that Mr. Paxton directed his employees to act contrary to the law enforcement exception and release confidential information related to an ongoing investigation. It is not a coincidence that Nate Paul had pending lawsuits concerning the open records request and the AG's no position opinion endorsed disclosing sealed documents. It is not a coincidence that even though there are over 40,000 open records rulings each year, the Nate's request is the first and the only time that Mr. Paxton ever cared about anything in the open records division. Now, after his advisors warned him repeatedly not to release law enforcement records relating to an ongoing investigation, Mr. Paxton insisted that the office issued the no position letter. The House has also established that Mr. Paxton provided Nate Paul with confidential information. It would be impossible for Nate Paul to know the specific details of who signed the sealed probable cause affidavit in connection with the application for the search warrant without being improperly provided that information by Paxton. In May, Mr. Paxton obtained a copy of the DPS file. That information was in there. He had the file for 7 to 10 days. The DPS file was in a manila envelope. It was testified it was a 1/4 inch or less in thickness. According to Mr. Wicker, in May or June of 2020, he handed off a manila envelope to Nate Paul at Nate Paul's office. In a meeting on August 5th, 2020, with Penley and Maxwell, Nate Paul and his lawyer presented a presentation titled Operation Longhorn, revealing that he knew the identity of the affiant and the probable cause affidavit that still remains sealed. There was also witness testimony explaining that Mr. Paxton asked that the information related to the ongoing law enforcement investigation be released. Listen to Mr. Vassar.
Was there a clear clash here between what the judicial system had decided somebody that should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking particularly harmful and dangerous to other people? If disclosed.
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
And still more.
What did the Attorney General say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened to Mr. Paul. He felt that Mr. Paul was being railroaded by the FBI and by DPS. And General Paxton said that he didn't trust law enforcement. He asked us to find a way to release the information that had been requested to be withheld.
So despite his staff telling him you can't release this type of information, despite Mr. Paxton's claim that the decision did not release any documents, the no position letter, that opinion, still created precedent that could help Nate Paul and could help others obtain confidential information. Listen to Mr. Banger about precedent.
If our office refuses to take a position on an issue like that and the court sees that, That is a strong signal, I believe, to the court. And I've been a lawyer for over a decade, probably close to 2. That's a strong signal to the court about the Attorney General's view of that file, that we would have gone out of our way to render a vastly uncharacteristic decision.
Let's talk about Article 5. Here's a summary of some of the key exhibits that we direct you to in your deliberations. Highlights: Mr. Paxton secretly signed a contract to hire Brandon Kamak, a 5-year lawyer with no prosecutorial experience, to commence a criminal investigation into Nate Paul's enemies. Mr. Paxton hired Kamak September 4th, 2020, and unbeknownst to his deputies, fully executed the contract 3 weeks later on September 28th. Paxton alone supervised Kamak's work, in which Nate Paul and his attorney Michael Wynn directed. Paxton thought it would be a good idea for Kamak to obtain grand jury subpoenas that would have allowed Nate Paul to get the private email and telephone records of law enforcement agents who investigated Nate Paul, lenders, and opposing counsel. Now, pursuant to the Texas Code of Criminal Procedure, Article 20A, I ask you to write that down. Texas Code of Criminal Procedure, Article 20, big capital A. The ability to obtain grand jury subpoenas is a prosecutorial act. It is not a tool available to outside counsel hired by the Office of Attorney General who has not been appointed an attorney pro tem. Now, let's talk about what that is. An attorney pro tem is appointed when a DA recuses herself, and it is a formal process in which that district attorney goes to the court and asks for permission to be recused. Kamak was not an attorney pro tem, but Paxton still permitted Kamak to obtain grand jury subpoenas just like he was. Thus, Paxton was illegally attempting to use Kamak as an attorney pro tem when under the law, which this legislature writes, says that cannot be. Paxton communicated with Kamak using only private encrypted communications like Signal and Proton Mail and extra phones. The two talked several times a week, and Kamak updated him about his work as a special prosecutor. Let's talk about that real quick. Even though Mr. Paxton called Kamak a special prosecutor, a term, special prosecutor, didn't exist. He clearly wasn't one. A special prosecutor is when a DA appoints someone to assist with their cases. And that person is not on the payroll at the district attorney's office, but is sworn in by the district attorney and becomes an assistant DA. And a special prosecutor, the DA continues to supervise the handling of their case. Kamak was not sworn in and was not supervised by the Travis County District Attorney's Office. Let's listen to the testimony of former DA Margaret Moore.
In what way? It is astonishingly untruthful. There is no way that anyone could interpret the facts as my appointing Mr. Kamak as a special prosecutor. I couldn't pick him out of a lineup today. I don't know him.
So he wasn't a special prosecutor and he wasn't an attorney pro tem. Let's hear from
By
Mr.
that
Mathieu.
time, the 29th, because the next day is when we go to the FBI and DOJ. By that time, I concluded that Mr. Paxton was engaged in conduct that was immoral, unethical, and I had a good faith belief that it was illegal.
This entire investigation by Mr. Kamak was illegal. Let's listen to Ranger Maxwell.
Now, would you agree with me, Ranger, that despite your concern or belief or hope that Mr. Wynn or Mr. Paul would say something incriminating or say something that would cause them exposure criminally, neither Mr. Wynn nor Mr. Paul ever asked you to do anything illegal.
Yes, they asked me to interfere with a federal investigation, which is absolutely illegal. It's also obstruction of justice.
Show me, Ranger, in the first hour or the second 2 hours on the investigation or the interview of July 21st or August 5th, you've got the transcript there for both of those.
Counselor, you are showing me the evidence right here. It's a map of how he wanted the investigation to be done and to have the AG's office follow how this was to be investigated, along with targeting 6 individuals.
Where they say, you reviewed the transcripts of the July 12th interview, and you have reviewed the transcripts of the August 5th interview. Show me the language where in either one of those interviews, Ranger, that they ask you to commit a crime.
They're not in the interviews, Counselor. They are in the document you're looking at right now. He lists 6 people as a person of interest to be targeted in this investigation.
Where does it add?
It's an Operation Longhorn.
What crime is Mr. Wynn or Mr. Paul asking you to commit by tendering this PowerPoint to you?
They entered the PowerPoint and gave it to us to map out how they felt our investigation that they wanted to be created should go.
What crime is committed, Ranger, by them asking you to investigate the legality of a search warrant? What crime is that?
In my professional opinion, to create this investigation and follow through it would be obstruction of justice and interfering with a federal investigation.
And finally, I ask you also to listen, recall testimony of Mr. McCarty.
And did you learn or see subpoenas, the grand jury subpoenas that had been issued to players in the Mitty Foundation case?
I saw a criminal grand jury subpoena that had been issued to a bank.
What was your reaction to that?
I was stunned.
What do you mean? Explain it.
I saw a criminal grand jury subpoena directed to a bank that was clearly seeking information that would have aided world-class Nate Paul's efforts against the Mitty Foundation.
Why is that bad?
Well, it's one thing is it's lawyer ethics 101. So that was the first thing that came to my mind. We are weaponizing the criminal process to aid a civil litigant, and that is a big no-no.
Ethics 101. And Mr. Paxton has not disputed the testimony of Mr. McCarty. Now, Brent Webster, on behalf of Mr. Paxton, misled the Senate Finance Committee by stating that he had proof that Mr. Kamek was an attorney pro tem because he was allegedly being supervised by the Travis County DA's office. I remind you of this testimony. This is...
I want to talk about the appointment of special prosecutors, and I don't know if you or the general need to answer that. Is it rare for your office to appoint a special prosecutor?
So, is this a general question about special prosecutors? Is that
just for the AG's office in general?
Okay.
Yeah,
I'm happy to address that. So,
I would actually rather if General Paxton would address it, but if
he knows this like backwards and forwards, he was a prosecutor, so he knows this issue very well.
Well, I'm wondering who hired Brandon Kamek.
That's right. So, if I can address that,
sure.
So our office entered into a contract for Brandon Kamek to be outside counsel. And so he was serving as outside counsel for the AG's office. Now, I have, through the process of, I started, as you know, in October after this happened, I have interviewed ADAs from Travis County, and I've seen documents from Travis County that prove the fact that the Travis County DA's office made Brandon Kamick a special prosecutor. We did not make Brandon Kamick a special prosecutor. That was within the purview of the Travis County DA's office. So the special prosecutor word gets confusing at times because there's two types. One type of prosecutor is a pro tem prosecutor, and a pro tem prosecutor can only be put in place when a DA's office recuses themselves from a case. And that's not what happened with the Brandon Kamick situation. We hired him to be outside counsel. That contract was signed by the general. And then he went to go work because he was hired on to assist the Travis County DA's office. And the news glosses this over. No one ever goes and looks at the Travis County DA's office's files. They don't give really deep interviews on these things. But the fact is, he went and said, I'm the guy that's going to be the outside counsel for the AG's office, and I'm here to assist on your investigation. And then through that process, he worked with them to get grand jury subpoenas, and that's how he became a special prosecutor.
And I'm aware of the difference. I actually wrote the legislation that determined on pro tem who could actually be appointed. So yes, I'm familiar with it.
This body knows the law. On September 29th of 2020, Jeff Mateer was leading a Zoom meeting about opioid litigation when he received an urgent message that there was an emergency. Mateer knew that it was something important. He learned that an individual representing himself as a special prosecutor for the Office of the Attorney General and Nate Paul's personal attorney had served a grand jury subpoena on a bank seeking information relating to Nate Paul and his activities. This was a crisis moment. Mateer called Bangert, Brickman, and other deputies who were in meetings at the Capitol. They assembled, shared the grand jury subpoena from the bank, and they were stunned and outraged. They realized that Mr. Paxton was using criminal grand jury subpoenas to aid Nate Paul's civil lawsuit against the Mitty Foundation. In that room, Bangert, Mays, McCarty, Penley, Vassar, and Brickman for the first time started to share from their puzzle pieces what their office was doing to benefit Nate Paul, not realizing how it all connected. The puzzle pieces came together that day, and they realized they had a massive problem. Concerns of bribery were raised. Mr. Paxton had allowed Nate Paul to infect the office at the highest level. Despite all their efforts, Mr. Paxton's senior staff realized they could not stop him. They believed that he had committed crimes and abused his office, and that he had attempted to involve them. They knew they had no choice but to report them. Mr. Paxton's counsel has argued with each witness, save one, claiming that they should have spoken to Ken Paxton before they went to the FBI. However, this line of questioning ignored the months and months of warnings, conversations, and pleas from senior staff, imploring that Mr. Paxton stop asking his office to do work for Nate Paul. Here's a video.
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
Let's hear what Ranger Maxwell had to say.
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
And Mr. Mateer?
I felt like we had been trying to protect Mr. Paxton. On several occasions, I'd gone to him, and really he was my boss. He'd become a friend. I cared for him. I cared for Senator Paxton. And I wanted him, I think in one of the memos I say, come clean. I wanted to help him.
And Mr. Penley?
I told him that I was trying to be a loyal subordinate and a friend,
and I still considered myself a friend even up to that very day. And I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it. I explained all the practical investigation difficulties, that we shouldn't be trying to investigate the feds, and there were many things we couldn't investigate. We didn't have the power. We didn't have a way to get at those sealed search warrants.
That's the testimony that you've heard during this trial. Now, Mr. Paxton's response was swift, vicious, and wrongful. He followed the classic playbook of guilty: deflect, deceive, and demonize. Articles 6, 7, 8, and 15 detail Mr. Paxton's attempts to misuse state resources to conceal his bad conduct by lying and smearing the otherwise stellar reputations of his loyal staff. Again, we list out some of the exhibits that we would direct you to during your deliberations. Please write them down if you can. He used state resources to issue an internal OAG report before this last election that contained blatantly false statements and personal smears against the whistleblowers. Let me remind you of what Mr. Brickman said.
In this report, if I asked you just to take three or four examples of things that you disagree with, have I asked you to do that?
Yes.
All right. What I wanted to ask you is, in this report, how would you describe your reaction to it as accuracy as in terms of what happened in these matters involving Nate Paul?
I would call this report a whitewash full of lies.
Now, if I may, let's just go over to page 5 and do this real quickly. If I ask you to pick 4 or 5 samples, can you just do that for me? And would you look on page 5 and see as to the first claim? What is untrue about that claim?
It says, on 2 prior occasions involving Nate Paul's interests, the Open Records Division sided with the government agency against disclosing to Nate Paul. That is not true. There was an Open Records decision that took no opinion as to the release of the documents.
On this number 2 here, where it says A.G. Paxton's involvement is consistent with his predecessors and in line with his required duties and legal obligations as Attorney General of Texas. Most relevant here, the position taken by the AG in this litigation was adverse to Nate Paul and in support of a higher settlement amount to be paid by Nate Paul to the Mitty Foundation, as opposed to the prospect of continued and costly litigation that would disproportionately benefit the charity's court-appointed receiver and his lawyer. All right, the third claim. This informal guidance letter regarding foreclosure sales written by Bangert was made in response to requests for disaster counsel advice from Texas Senator Brian Hughes during the height of the pandemic and not for the benefit of Nate Paul. Is that a true or untrue statement? Is that a true or untrue statement?
It is an untrue statement. The foreclosure opinion was for Nate Paul's benefit.
Can we go to page 6, please? Look at the top. Kamak legally and properly exercised authority delegated to him by both A.G. Paxton and the TCDAO. Kamak was designated as outside counsel for OAG by A.G. Paxton, and he was also knowingly appointed as a special prosecutor by the Travis County DA's office. Is that a true or untrue statement?
It is false.
Mr. Paxton did not examine or cross-examine a single thing said by Blake Brickman. Every word he said is unrefuted. Let's look at a quick timeline. I want to remind you that the whistleblowers were all constructively terminated within 45 days of making their report to the Trump FBI. Mr. Paxton last attempted to silence the whistleblowers with his request to the taxpayers that the taxpayers pay $3.3 million in hush money. Even when he was specifically asked to justify the use of the money he declined and refused. And that is why we are here. Mr. Paxton refuses to take any responsibility for abusing the esteemed office that he holds. Let's look at Articles 9 and 10. In exchange for abusing his office to help Nate Paul, Mr. Paxton reaped tangible benefits. What we know is that Nate Paul gave Mr. Paxton's mistress a job so that she could move from San Antonio to Austin to be closer, provided free Uber rides to her apartment. And Nate Paul provided free renovations to Mr. Paxton's Austin home until he was caught. And I'll show you that in just a minute. Look at this next chart. It has a lot of data on it, but just look at the colors for me. This chart is a demonstrative based on Exhibit 700. Exhibit 700. Marked in orange are trips to and from Miss Olson's residence, which is shown as Exhibit 699. Marked in blue are trips to Nate Paul's residence. Exhibit 700 shows that Nate Paul set up an Uber account for Dave P. The account facilitated a covert means for Paxton to maintain his affair. The ride chart in this exhibit contains the latitude and longitude for each pickup and drop-off for Dave P. Focus on the rides between July 30th, 2020 and October 2nd, 2020, when the rides suddenly stopped. October 2nd. Next, I show you this Uber exhibit also shows that the rides are paid for with a credit card linked to Nate Paul's billing address in Austin and not Ken Paxton's in Collin County. Not Ken Paxton's in Collin County. Next, I show you Exhibit 699, which shows that Laura Olson was hired by World Class Property Company July 6th, 2020, and reports to Nate Paul. Let's talk about a timeline that's really important. You've seen a lot of documents, but let's take a moment. I want to show you this timeline. It's important. This shows when Paxton found out about the whistleblower report to the FBI and the actions that he took immediately after that. Now, Penley emails Kamek to tell him to cease and desist at 9:18 on September 30th, 9:18 in the morning. At 10:35 that morning, Kamek forwards the email to Paxton's Proton mail address. Kamek relentlessly calls Paxton that morning as well. Only 4 hours later, Paxton decides to pay the Cupertino builders for renovation work completed in July. Completed in July, but we're paying them now, September 30th. He returns to Austin and arrives at the airport at 10 p.m. At 10:57 p.m., Dave P. takes an Uber to Nate Paul's house. Dave P. was picked up 1 block from Paxton's residence. The next day, October 1st, that was the 30th, the next day, October 1st, Cupertino Builders creates an invoice for Paxton at 7:50 p.m. The records show that this invoice was never sent to Mr. Paxton. That night, October 1st, Dave P. takes his last ride to the Pearl Lantana Apartments, where Laura Olson lives. We tried to call her as a witness. The court announced that she was present but unavailable to testify. Next, this is an invoice from Nate Paul's guy, Raj. Never sent to Paxton. He created it after it was due, and the metadata tells us so. The metadata tells us it was created on October 1, yet Mr. Paxton decided to make payment on September 30th for work that had been completed in July. This is Exhibit 703. These are emails. Why does Nate Paul need to know the schedule for the renovations at the Paxton's home in Austin? Why does Nate Paul need 20 photos of the new flooring in the Paxton's home in Austin? Mr. Wicker testified that he heard Kevin Wood tell Mr. Paxton, "I will have to check with Nate," at least 3 times. Kevin Wood, who avoided being served multiple times with subpoenas in this matter. There are no coincidences in Austin. Nate Paul was paying for these home renovations until it all got found out. Articles 16 through 20. They charge that Mr. Paxton and Nate Paul's scheme to use the powers of the Office of Attorney General constituted dereliction of duty, made him unfit for office, and abused the public trust. These articles ask the Senate to do exactly what Mr. Paxton's counsel is begging you not to do, to look at the entirety of Mr. Paxton's conduct. And when the Senate does so, there is no reasonable doubt that Mr. Paxton committed the acts set forth in these articles, and that these acts were an abuse of office and a breach of public trust. The witnesses have explained to you that Mr. Paxton conspired with Nate Paul and others to harass and intimidate their perceived enemies. While Mr. Paxton's attorney suggests that there must be some type of overtly stated agreement if people are going to conspire, he also knows there are no coincidences in Austin. Mr. Paxton was using an inordinate amount of the OAG's resources for Nate Paul. Listen in.
Well, when the Attorney General kept raising Nate Paul issues of the ones that we've gone through so far and later in the future, do you have any idea how much time or resources that were devoted to dealing with Nate Paul instead of real concerns?
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
The burden of proof in this case is beyond a reasonable doubt. Well, what does that mean? It means exactly what the words say. Is there doubt? And is it reasonable? Even though this isn't a criminal trial, every day in this country, criminal defendants are convicted of crimes beyond a reasonable doubt with much less evidence than you have seen in this trial. We admitted over 3,000 pages of documents and 7 days worth of testimony, and that will all be accessible to you in your deliberations. When we first started our case, it might have been unclear what all the evidence was. And that doubt was reasonable since Mr. Paxton was presumed innocent. But as more evidence came in, the picture became clearer and the doubt faded. The puzzle pieces came together. The law does not require that we exclude all doubt. When we have shown you enough evidence that you can see what the puzzle is showing, that you know what the picture is, then we have met our burden. Now, Mr. Paxton's counsel would urge you that we have to put every piece in the puzzle there for it to be a picture, but that is not what our burden is. The burden is satisfied. Is it a coincidence that Paxton ordered his people to intervene in the Mitty lawsuit when they had already waived intervention? Is it a coincidence that Nate Paul used the midnight opinion to stop a foreclosure sale 1 day after the opinion was issued? Is it a coincidence that while discussing the Paxton home renovations, Mr. Paxton's contractor told him at least 3 times, "I will have to check with Nate"? Is it a coincidence that Nate Paul gave Ken Paxton's mistress, Laura Olson, a job while Mr. Paxton was doing Nate's bidding? Is it a coincidence that within 45 days of reporting to the Trump FBI, every whistleblower was terminated or constructively discharged? My counsel talked about $25,000 campaign contribution from Nate Paul in 2018. And he told you that Mr. Paxton is a fundraising machine. Well, in our world, that is a good campaign donor. That is a donor that you have a race. The next year you pick up the phone and you call. There should be a campaign donation in 2019. Where is that? There should be a campaign donation in 2020. That is a good donor. Is it a coincidence that there is no longer campaign contributions? There are no coincidences in Austin. Members of the jury, this is the most important choice you have ever faced. In 100 years, it's probably the only vote that anyone will ever talk about in your careers. It will also decide what Texas politics look like, not just to the way cynical people outside this chamber think, but this is about what does public service mean. Public service. To Mr. Paxton, it meant serving himself and his friend Nate Paul. Mr. Paul brought incredible wealth and a lavish lifestyle to the partnership. And Mr. Paxton brought the incredible power of the state. And the defense here isn't that he didn't do it, it's that it doesn't matter because he won the election. You know, Mr. Kinghorn summed it up in his testimony yesterday. The office of the Attorney General of the state of Texas is Mr. Paxton's law firm, and he is the firm's only client. He directs it to serve himself, not the people of Texas. If you vote to condone that, then high office will simply be the most profitable choice for any self-serving crook, and it won't even have to be hidden. You're here despite political pressure because you believe that public service is a calling that you put people first. You have everything in common with the whistleblowers, each a faithful servant who has spent years fighting for their values with great integrity. Look at what Mr. Paxton did to them. Think of Ranger Maxwell. In September of 2020, he was a Hall of Fame hero with 40 years of experience, a man of honor above reproach. 1 month later, that lifetime of service meant nothing. When he was an obstacle to Mr. Paxton, he was suddenly a liar, a rogue, a liability that had to be fired. We say we back the blue in this building, but Mr. Paxton tossed him out with the others like the garbage. If you don't hold Mr. Paxton accountable, that could happen to any of us. Your entire legacy could be erased and rewritten on the whim of whoever wins the next election. That is a godless, rudderless morality, and it cannot be the new normal for Texas. We must have a shared standard of integrity, honesty, and service that transcends any election. Your vote will set that standard.
Mr. Mayor, you have 10 minutes left.
Now, at the beginning of trial, we watched all of you place your hand on Sam Houston's Bible and take your oath. Sam Houston's Bible. At that time, I reminded you that Sam Houston told Texans, do right and risk the consequences. Now is your time to do right. Mr. President.
Mr. Leach, you have about 9 minutes.
Thank you, Lieutenant Governor, distinguished members of the Senate, my fellow House members, General Paxton, and to the people of Texas. Let's be very clear. None of us want to be here today. I don't, and I'm confident that you don't either. But here we are with a heavy and historic moment in front of us. I stand before you today humbly on behalf of the House Board of Managers to offer a few brief closing remarks. These remarks have not been reviewed by anyone. I didn't go to dinner with TLR last night. George P. Bush didn't have his speechwriter draft this for me. Karl Rove's not sitting in my office right now. This is me, and me alone. 10 days ago, as these proceedings commenced, I watched each of you, I sat right over here, and I watched each of you, senators, place your hand one by one on Sam Houston's Bible, swearing to impartially render a verdict based on the law and the evidence. And as Chairman Murr has just articulately outlined for you, the House Board of Managers believe that that evidence meets the high standard of beyond a reasonable doubt. And as strong as we believe the evidence to be, make no mistake, this is not an easy vote for you. It's not. It shouldn't be, and I trust that it's not. It wasn't for me. This will, if you're like me, be the hardest vote, the most difficult vote, the heaviest vote that you will ever cast in your time in the legislature. This proceeding, we've had a lot of discussion about whether this proceeding is civil or criminal in nature, and as we've learned, it's been a unique mix of both. But it's also very personal. The vote that each of you will cast, I should say the 16 votes that each of you will cast, will be very personal, and they should be. We should treat the heaviness and the historic nature of this moment with the weight that it deserves. Members, senators, I certainly have done so. In voting to impeach General Ken Paxton, my dear friend, a political mentor, a brother in Christ, and a once trusted advisor, this has not just been a hard vote, this has been one of the most difficult things I've ever had to do in my life. Mr. Busby, you said in your closing that we're here because we hate Ken Paxton, and you could not be more wrong. I have loved Ken Paxton for a long time. I've done life with Ken Paxton. We've traveled together, attended church together, attended countless Cowboys and Baylor football games together. Heck, we're both former Baylor student body presidents.
You have 5 minutes.
I've block walked for Ken. I've donated to Ken, supported Ken. I've asked others to do the same. The first bill that I ever passed in the legislature in 2013, the only bill I passed that session, was sponsored by then Senator Ken Paxton. Which is one of the reasons that this is so difficult for me and many of our House members, and I know for many of you, it will be as well. Over the years, Ken and I have spent hours on the phone together. We've texted. We've called. For the first years after he was elected Attorney General and when he took office, I had an open door to the Attorney General's office. I could go up to the 8th floor anytime and visit with my friend. We talked politics and policy. We talked life. Members, I know, as I look across this floor, many of you had the same. But a few years ago, those calls stopped, and that open door was closed. And I became increasingly concerned and alarmed at what I saw.
Your Honor, he's testifying, and this is not proper. This is not based on any evidence in this case. It's improper.
Mr. Busby, this is closing argument.
I understand what it is, but I'm just saying he's talking about personal things that were not put into evidence.
Mr. Busby and Mr. Leach, the jury will decide what is evidence. Okay.
Thank you, Lieutenant Governor. Members, senators, this has been, the point is, I know it's not lost on you, senators. This is difficult for me. It's been difficult for many of us, and I know it will be difficult for you, and it should be. While the law and the evidence is clear, this is a personal vote for you, and it should be. But make no mistake, we shouldn't have to be here. I, like many of you, in response to those concerns, attempted to get answers, to have conversations, to schedule meetings. I called General Paxton in front of our committee 12 times this session, and not once did he appear in front of our committee for answers. And with all due respect to my friend, Mr. Cogdell, we do not, as legislators, have to go through private counsel to have access to a statewide official. Senator Huffman, if you wanted to meet and have Comptroller Hager come in front of your committee, you don't have to go to his private counsel. Senator Creighton, You don't have to contact Mike Morath's private lawyer for him to come in front of your committee. Not once did he come answer questions in public or in private, which is largely one of the reasons that we're here today, because the people of Texas deserve answers, and the legislature, the Senate and the House, expected to get those answers. Members, in closing, I see some of the whistleblowers are here in the gallery this morning. These are men and women of high esteem, character, conservative to the core. And you courageously spoke out, knowing the consequences and taking the risk, much like all of us have had to do and will have to do with this vote. I want you to know that the House has seen you and heard you. Mr. Maxwell, I see you. You deserve more than to be ridiculed and mocked on the floor of the Texas Senate. We hear you and we see you. The House has, and I'm confident that the Senate will as well. In closing, one of my favorite quotes is a quote of Martin Luther King. He says that, quote, cowardice asks the question, is it safe? Expedience asks the question, is it politic? And vanity asks the question, is it popular? But conscience asks the question, is it right? And there comes a time for each of us. There will come a time for you. I believe this is it. Not to ask yourself what is safe or popular or politic, but what is right. And I believe that it is right, as painful as it might be, for us and for you to vote to sustain the articles of impeachment commended to you by the Texas House of Representatives. It's an honor to serve with each of you. I pray God's grace and favor and his wisdom and discernment over you as you deliberate and vote on this historic matter. May God bless you, senators, and may God bless the people of Texas. Thank you.
Thank you, Mr. Leach. Thank you, counselors from both sides. Under the rules passed by the Senate, written and passed by the Senate 25-3, Rule 27 says that I shall give you the following instruction to the Senate jurors before deliberations begin. And as a reminder to everyone who may have tuned in late, we have no idea how long deliberations will take, but we will try to notify you once every member has decided they are ready to come to the floor and vote. And we will alert the media, and we will put it up on the website 30 minutes or a little bit more so that you can be aware of when the senators will be back on the floor to vote individually on all 16 articles. These are the instructions as you have written. Sustaining an article of impeachment means that the impeached officer is removed from office for the term the officer was last elected. You are instructed that the rules adopted by the Court of Impeachment establish that the burden of proof rests on the House Board of Managers to prove an article of impeachment beyond a reasonable doubt. You are to determine if the allegation in each article presented to you has been proven beyond a reasonable doubt. And if so, shall the article of impeachment be sustained, which would result in removal from office? The final question to be put to you after each article is, shall this article of impeachment be sustained? Members, we will adjourn for this day very shortly. You will go to deliberate. I want to repeat that if the deliberations last until the night, when you leave here, you're not to talk to anyone about this trial. You're not to talk or watch anything on television about this trial. Go online and surf any news. You have serious work to do. And I believe that you will do it in a serious and responsible fashion. I'm going to order you to work to at least 8 tonight in deliberations. You can work longer if you wish. To be back here, if you have not come to a decision today on all 16 articles, to come back tomorrow morning at 9 a.m. and work until 8 tomorrow night. If a decision is still not reached, to be here at noon on Sunday. And if a decision is not reached by late Sunday night, I may take the option of sequestering you in the building. We all have slept overnight in our office once or twice. I know I have. Take as much time as you need to come to the decision that you believe is the right decision. God bless all of you. Thank you for your service to Texas. We stand adjourned until the members notify my office that they are ready to return and vote on all 16 articles. Members, the clerk will pass out all the articles of impeachment to you as required so you can take with you. Yeah. Members retire to the deliberation room. No mingling on the floor with anyone except each other.
So there we have it. 11:53 is officially the time that the senators, the jurors, have been dismissed to begin deliberating those 16 articles of impeachment that the Senate is considering against Attorney General Ken Paxton. They will eventually say they are done deliberating. Again, this is not a group deliberation like you may see in a criminal or civil trial. Instead, each of the senators are just simply deciding how they will vote. So because of that, we do not expect it to maybe take as long as a typical jury process may take.
To the media and counsel, as appropriate, it will be time to clear
Senate Governor Dan Patrick
as this chamber will
announcing that they'll be closing the Senate chambers,
jury returns.
At least briefly, until the deliberations are complete. Let's go over the numbers briefly before we wrap up and recap some of what we heard in closing arguments. Again, 21 is the magic number on each of those articles of impeachment. They're going to take separate votes for each of those articles. 21 is required to sustain an article of impeachment, which would lead to removal from office. There are 12 Democrats. If we assume that all 12 Democrats vote to sustain the articles on each of those articles of impeachment, there would be 9 Republicans required to reach that threshold for removal. Because it is a 2/3 majority, there are 30 senators voting, but 31 that make up the body, because Senator Angela Paxton cannot vote in this matter due to it involving her husband. So 21 will be the number we are listing for once we hear those votes start to happen, and we will hear those go one by one, where we hear each of those senators enter their vote. At least that is what we expect. He would then be removed from office for the remainder of his term at least. Talking about the closing arguments and the strategy here, I think is really worth pointing out what we saw at the end there from the House team in bringing Representative Jeff Leach from Plano, one of the Collin County Republicans. That delegation in the House all voted for impeachment. They put out a statement afterwards announcing their decision. And so on the front end of the House's closing arguments, you heard more of a methodical approach to walking through and kind of recapping what the case was. That last 10 minutes or so where we heard from Representative Jeff Leach was essentially, it seems, geared at getting at the heartstrings, pulling at the heartstrings, and the conservative values of those Republican senators who are weighing this decision and will have to explain their decision to their voters when they are next up for re-election. 6 of those Republican senators up for re-election in 2024, and so not too far away. You heard Representative Leach appearing to get emotional at points, describing what once was a close relationship that he had with Attorney General Ken Paxton. His power base being in Collin County. It's where he represented the area as a state senator before becoming the Attorney General. And so Jeff Leach was trying to level with those senators essentially and say, I understand how difficult of a decision this is. We did not want to be here, but this is the position we are in. And you did see at one point in time the defense tried to object and cut off some of that, and Lieutenant Governor Dan Patrick said that the senators could parse through that on their own and decide whether what he was saying was evidence or not. On the flip side, the defense, it was a completely different strategy, something that was much more aggressive, accusatory, brought up the idea that this is a conspiracy multiple times throughout, accuse the House impeachment managers of their actions being shameful in bringing these activities forward, and they claim that there was not evidence. Again, because the House was able to reserve much of their time for the back end, they were able to attempt to rebut those claims and say, when we say this happened, this is the evidence that we are pointing to. It will, of course, be up for the senators to decide for themselves whether that evidence is enough to lead them to sustaining. Sustaining is essentially what is guilty in this matter, whether they will sustain on any of those articles of impeachment. You heard Lieutenant Governor Dan Patrick saying that they will go until at least, or they'll go until 8 o'clock tonight. And the senators are basically going to be limited from doing much business beyond this. They are not supposed to really talk with other people, except for maybe their families. They are not to watch news coverage, not to be really doing other business besides impeachment during this. And so, again, we really do not expect that these deliberations are going to take very long. We are told that there will be at least a 30-minute heads up we get when all of those jurors have decided that they have deliberated for enough time. They can talk with one another when they're in that deliberation room. Keep that in mind. And so there certainly could be some political conversations playing out. This is a political trial at the end of the day, not a criminal or civil trial. And so there no doubt will be maneuvering that is going on among those conversations. We will, of course, be following this. I encourage you, if you have not already, to download our Fox 4 News app. Obviously, if you're streaming here on Fox Local, a great way where we'll be bringing you verdict coverage if and when that happens this afternoon. And of course, we'll stay on top of it this weekend. We will push out alerts to you on our app and on our social media pages when we begin to get word that the deliberations are done and we're about to have the votes or verdicts, if you will, happen. But for now, we are going to sign off, and we will be back with you when we get word that the Senate has reached their decisions.